Call the meeting to order. This is the May 24th, 2016 meeting of the Fairfield Town Plan and Zoning Commission. First item on the agenda are the meeting minutes from May 10, 2016. Motion to approve by Commissioner Coleman. Second by Commissioner Francis. Did everyone have a copy of those? I reviewed them. I didn't see anything that needed any corrections or the like.
No issues.
No issues. Ready to vote? Okay. All in favor of the minutes signify by saying aye.
Aye.
Any opposed? Abstentions? Okay, the minutes are adopted unanimously. Next item is 75 Senior Place. Request of Attorney Christopher Russo for a 90-day extension for recording a final subdivision map. It is first request.
Yes, Mr. Chairman, this is a two-lot subdivision approved by this commission on March 8th. This is the first of two possible 90-day extensions. You will, I'm sure, recall that this subdivision includes the conclusion of a purchase of land from the state of Connecticut in order for that map to be recorded, and that has not yet been finalized. This is the primary reason for the extension.
Very good. Thank you. So this is a request for extension as a matter of right.
Move to approve it?
Motion to approve by Commissioner Coleman.
Second motion.
Second by Commissioner McAleese. Anyone have anything to say on this? All in favor signify by saying aye.
Aye.
Any opposed? Abstentions? The extension is granted unanimously. Next item is 665 Commerce Drive. Request of Scala Partners for a 50% release of a $397,055 bond pertaining to special permit improvements in the design commercial district.
This is the mixed-use project on the corner of Black Rock Turnpike and Commerce Drive. It's coming along. The work completed to date includes the vast majority of the on-site drainage system, including a very large underground detention system, which was by itself about 40% of that bond. We went out there with the engineering department and reviewed what the items, the bonded items that have been done, and they concur that 50% of the work has been completed.
And I know we also have a note in the file from Scott Lehman regarding confirmation of that as well. Okay. Can I have a motion?
So moved.
Motion to approve by Commissioner Francis.
Second.
Second by Commissioner Coleman. Does anyone have any questions on this? Ready to vote? All in favor signify by saying aye.
Aye.
Any opposed? Abstentions? The bond is release, 50% is granted unanimously. Next item, new applications to recommend a public hearing. 256 Spruce Street, zone change application of Michael Chanella to establish a design commercial district on land presently zoned Residence B and zoning compliance application for off-street parking.
This is a very similar application that this commission has seen before. Was denied in October of 2014. It is a similar application, but it's been more than 12 months. So you do have the right not to hear the same application for a period of 12 months. It's been well over that time, and they're taking another crack at it. Does require a public hearing.
So, requires a public hearing, and they waited beyond the
requisite 12 months,
period in which we could deny it for convenience.
I move that we move it to public hearing.
Motion to move to public hearing by Commissioner Coleman.
I'll second.
Second by Commissioner Barrett. Any other discussion? There's not a whole lot, public hearing's required, so it's, okay. All in favor signify by saying aye. Aye. Any opposed? Abstentions? Move to public hearing unanimously. Next item is old business, 845 and 917 Mill Hill Terrace and 130 and 156 Pease Avenue. Special exception application of Maplewood Senior Living pertaining to the construction of an assisted living facility in the A, B, R3, and DRD zones.
Yeah, Mr. Chairman, before we go through any kind of overview of this, I know there's a couple commission members are not available for this evening, and they have requested a table on this item, so I wonder if the board wants to consider that first.
Sure.
Before we go over the overview.
Yeah. So, I had a couple things to say, about that as well. kind of have a skeleton crew here this evening for, one reason or another. There are also a number of things that I'm still considering. It's a fairly complex application. It involves the offering of some land for open space and sidewalks and remediation, and we had 3 nights of testimony. We have plenty of time on this. The vice chairman specifically said that he wanted to participate in this, so I would entertain a motion to table this item.
Mr. Chairman, I make a motion to table for discussion.
Motion to table by Commissioner McAleese,
I second it.
second by Commissioner Francis. Does anyone have anything more to add? I'm sorry, Commissioner Coleman. I've done that. I was so good at that for so long. Yes.
Mr. Chair, I
Barris.
agree, I support the motion to table. I mean, even if, we can decide things with 5, but the vice chairman asked to participate in it, and that's, we have time, so just based on that alone, I would say we should table it. We can consider it more and take it up at our next meeting, so I support that.
Yeah, I wanted to get a sense of, how people felt about that, because there are still a number of things that I personally am reviewing and going back to the tapes, and, there's a lot of moving parts to this. There really is. And we have, like I said, we have plenty of time, so. Commissioner Coleman, anything more to add? Okay. Are we ready to vote?
Yes.
All in favor signify by saying aye. Aye. Any opposed? Abstentions? The item is tabled unanimously. Next item is compliances. 1011 Fairfield Beach Road, coastal site plan application of Anthony Giaro pertaining to the construction of a single-family dwelling in the Beach District.
This is an application for a single-family house. There was a house on this property that suffered severe damage, Storm Sandy, and as a result, it was ultimately demolished. This is a successor purchaser that's looking to build a FEMA-compliant structure on the premises that meets with our Beach District requirements. This and the following application have been referred to DEEP for comment, and they did not choose to offer any substantive comments. We believe it's consistent with the coastal management policies as outlined in the report, and in our opinion, it's in compliance.
Thank you. Can I have a motion? Someone? Commissioner Barrett?
I make a motion to approve.
Motion to approve by Commissioner Barrett,
I'll second it.
second by Commissioner Coleman. Thank you. Does anybody have any comments on this? So I reviewed this. Everything appears to be, consistent with our regulations. A review by the, from the Coastal Area Management Plan review was, all buttoned up. The only thing, as a question for staff, is that, many of the items comment that they are consistent with the plan, so long as erosion control measures and FEMA guidelines are employed during any permitted construction. Do we need to make that a condition of approval?
I don't believe so. I think the plans themselves, there's provisions in our regulations say compliance with the plans that are submitted are generally considered a condition of approval, so I don't think you need to articulate it beyond that.
Right.
It's, during the course of construction, we'll be out there periodically, and if they're not in compliance, we'll take steps to make
Right.
sure that they are, so. You can if you deem it appropriate, but in my opinion, I don't think it's necessary.
Yeah. I almost felt like it was a non sequitur. Like, they were reviewing the plans, which were submitted consistent with FEMA guidelines and so forth, as they were required to do so, and the conclusion was, so long as you follow the plan that you submitted, it should be okay. You know what I mean? Like, yeah. So why else are you submitting the plan if it's not to be consistent with what you're telling me you're going to do? All right.
Yeah. I think,
Commissioner Barrett?
yeah, I think sometimes Mr. Biankowski, the planner that does these things, actually puts in recommended
Yeah.
conditions and things
Yeah,
like that.
there-
And here I didn't see any really, other than...
Yeah,
so
I would agree with that. There are occasions, and I believe we had one on the last agenda, as a matter of fact, that warranted a condition, and
Yeah.
I would agree with that assessment.
Yeah,
Right,
so-
so there's nothing here. Okay. Anyone else have any questions, comments? Ready to vote? Okay. Commissioner Kennelly, are you on this?
I can be on this, yeah.
Okay. All in favor signify by saying aye. Aye. Any opposed? Abstentions? The compliance is passed unanimously. Next item is 353 Old Dam Road, coastal site plan application of Mario Smith pertaining to the construction of a single-family dwelling in the Beach District.
Similar remarks than as the previous application, with the exception of this house is still standing. It didn't suffer severe damage as a result, but the plan is to demolish the existing dwelling on the property and build a new FEMA-compliant structure. Other than that, again, pursuant to the report, you didn't have the hard copy, our apologies there, in your packet. We emailed it subsequently, but a similar recommendation, we believe it complies.
Right, and similarly, there were no recommendations
That's
or
correct.
conditions of approval on that. Okay. Can I have a motion?
Motion to approve.
Motion to approve by Commissioner Francis,
Second.
second by Commissioner Coleman. So apart from those comments, does anyone have anything to ask? No, it looks pretty straightforward. All in favor signify by saying aye. Aye. Any opposed? Abstentions? The compliance is passed unanimously. Next item is public hearing, 92 and 140 Bronson Road, a review of revised plans for a 91-unit residential building pursuant to Connecticut General Statute, Section 830G. This proceeding is pursuant to a remand by the Connecticut Superior Court and does not constitute a new application. This is in the Residence A zone.
Good evening, Mr. Chairman and members of the Commission. For the record, my name is John Fallon. I apologize for my Polleny voice, but if there's ever been a desire that Fallon gets laryngitis, your prayers have been answered, so I will try to keep my voice up. I think it's important to start here with what brings us here, and that is the matter of the remand. On September 10 of 2015, Judge Bates rendered his decision, which I know you all have a copy of. And in that decision, he reversed the Commission's denial of the Garden Homes 8-30G application. In so doing, I want to direct your attention to page 8 and 9 in particular, because I think it's important to point out that the judge expressly approved the development with one 20-foot access way. At page 8, he states in part, several witnesses, including Fellner, referring to the former police chief, raised concerns about the lack of a second means of access to the building in the event of emergency. These concerns took the form of two issues. First, the general desirability of having two means of access, and second, criticism of the adequacy of the proposed access way. The judge goes on to say at the bottom of page 8, 8-30G mandates that once it identifies such a concern, the Commission has the burden of proving that the public interest cannot be protected by reasonable changes to the affordable housing plan. At page 9, Judge Bates continues, on the final night of public hearings, the applicant submitted a sketch featuring a potential conditions of approval regarding this issue. This proposal eliminated 4 parking spaces and 3 units and purported to afford larger vehicles, such as the fire trucks and moving vans, sufficient space to access the building and to turn around so as to avoid a reverse travel while exiting the site. The court goes on to say, and I quote, given this court's holding that the 20-foot wide access way is acceptable, again, given the court's holding that the 20-foot wide access way is acceptable, this court will remand the issue of the most recent redesign of the access way and apartment building discussed above, as proposed by the applicant, for due consideration by the commission. The judge goes on to say, with the submission of the proposal for a turnaround area for ladder trucks, the applicant also submitted a plan.
Where are you now?
I'm at the bottom of page 9.
Okay, so you just skipped the rest of that paragraph?
I did.
And you skipped into the next paragraph?
I did. I figure you've all read the decision.
Well, we have, but since you're reading portions of it into the record, you might want to continue, because it says the ability of fire trucks to enter and turn around in the parking lot is an issue of health and safety, which is part of what we need to consider on the remand. Would you agree?
Correct, but I return to the court's holding. Given the court's holding that the 20-foot wide access way is acceptable.
Well, you read that already.
I did. And
Yeah,
I think...
And we now need to consider what the court has remanded the case to us.
And what the
consider.
court has specifically remanded to you for consideration are two things. The turnaround that is proposed for emergency vehicles, and two, consideration of a proposed reinforced shoulder that will provide a wider traffic path for emergency vehicles. That is the point of the remand.
Well, the court also says the ability of moving and large delivery trucks to do the same is an issue of health and safety to a lesser degree,
Correct.
but should also be reviewed.
Right. And
So why are you challenging me on the issue of reviewing the entrance and turning around in the parking lot and the ability of moving large trucks around in the parking
I'm
lot?
not challenging you on anything.
Okay.
I'm simply pointing out that the court explicitly found the 20-foot wide access way to be, quote, acceptable. And the court charged you on remand with consideration for both vehicles involving fire or delivery of a turnaround, and for consideration of the applicant's pro-offer of a 2-foot wide permeable pavement.
Right, all with respect to the public health and safety.
As it relates
So,
as
you
it
know,
relates to those two issues.
All right, the fire trucks entering the site and turning around for health and safety is to, do their job, to fight fires and to enter and move about the facility
Where
and do
we
what they need to
disagree,
do.
Mr. Chairman, respectfully, is that the remand countenances your review of the suitability of the access. That has been judicially determined. What the court has asked you to look at on remand is our proposal made at the time of the hearing for a turnaround that would improve circulation for such vehicles.
Right, and we have to do so in the context of the site plan and health and safety, such that the fire trucks and the moving trucks and the delivery trucks can do what they need to do on the site and all the rest of it.
As long as that scope of review on this remand is limited to the turnaround and the widening of the access way, then we have no quarrel. Where we would have...
Listen, the proposal you made is in writing, it's in the record,
Right.
right? There was a response by the fire department and the police, the fire chief is here to present, their review of the, the revised plan and your arguments and all that kind of stuff. And we will consider what we are charged to consider by the court, and we have to make a decision.
That's the only basis of my remarks, and I appreciate that because we share that sentiment. So my point with regard to the remand is, as I just said, those are the two issues that I think are before you this evening. With regard to the legal authority involving what is the scope of your jurisdiction on a remand, I'd say a couple of cases to you. The scope of the remand determines the finality of the judgment. That's from Kaufman versus Danbury Zoning Commission, 232 Connecticut 122. Remands are final to the extent they deprive the agency of discretion beyond the items that are the subject of the remand. And that's Avalon Bay versus Stratford Zoning Commission, 284 Connecticut 124. It is our respectful position that Judge Bates's decision leaves the court, the commission, no discretion over matters that have already been ruled on by the court involving the width of the access road, the number of access ways, or any other aspects of the application except consideration, at the court's suggestion, of the reinforced shoulder and the turnaround, along with changes that are ancillary to accommodating those issues. For example, we've had to reduce the unit count by 4 units because we obviously had to reduce the parking to accommodate the judge's request and our pro-offered suggestion on the turnaround.
If I can just interrupt you there again. So I understand you're saying you've not, your revised plan is consistent with a 20-foot wide access way.
Correct.
And we need to look at the revised plan with the fewer parking spaces, et cetera, in light of the proposed 20-foot wide access way.
No.
And whether the revised plan enables the fire trucks to enter and turn around in the parking lot to provide health and safety, whether the moving and large delivery trucks can do the same, should also be reviewed. I mean, we have to look at the revised plan in that context on remand from the
Respectfully,
Superior Court.
no. If you're indicating that you think on this remand, you have the right to revisit the issue of the 20-foot access way, I would respectfully submit that you're incorrect.
No. I'm not, your revised plan includes a 20-foot access way.
Correct.
And the question before us is whether your revised plan accommodates the health and safety issues that we need to consider.
No.
He says it right here on page 9.
Given the court's holding that the 20-foot wide access way is acceptable, what the court remands back is consideration of the improved turnaround and the 2-foot permeable shoulder. Now, maybe we're missing each other in terms of communication, but that's my point. And my point is this remand on its face does not allow the commission to revisit whether or not, as a matter of public health and safety, the 20-foot access way, or the fact that there is one access way, is appropriate.
You know, we'll have to hear the evidence. And
Judge Bates
we'll have to consider, you know, all of the facts and the case and the court's decision and
Right.
and the case law, and we'll have to make a decision. I understand you to be saying, and I understand from a review of the plan, that the 20-foot access way hasn't changed, and there's only one of them.
Correct.
And we need to review the revised plan, hear your, whatever presentation you'd like to make. We have a submission from the fire chief
Which
of
I
the
will
fire
address.
department, which we're going to hear. If there are other members of the public that have, issues to bear, facts and witnesses or evidence or whatever, to bear on that, we'll hear that too. I will let everyone know that the comments and submission of public comment and witnesses and evidence will be strictly limited to the issues on remand
Fine.
that we have to consider.
That's
And
all.
that relates to the turnaround, the health and safety of the fire trucks being able to enter and turn around and do their job on the site, along with moving and large delivery trucks, et cetera.
The only place I disagree with your comment, respectfully, and without being redundant, is the use of the word enter. Because enter means that you perceive on the remand that the access way's adequacy is something you can consider. And the judge and the court has decided that. What has the judge remanded to you is the turnaround and the 2-foot shoulder.
I mean, in some ways, we may be, in some ways, we may just have to do our jobs and
Right.
sort of see. But I'm reading the words on the page.
As am I.
And they say, the ability of fire trucks to enter and turn around in the parking lot is an issue of health and safety.
And I
Hold
read-
on, period. The ability of moving and large delivery trucks to do the same is an issue of health and safety to a lesser degree, but should also be reviewed. So the task here, I think, is quite clear. And I don't know that we need to argue about it anymore. But
And we
words say
won't.
what they say.
The only place where I read that you don't, apparently, is, given this court's holding that the 20-foot wide access way is acceptable, the court will remand the issues of the most recent redesign. That's the 2-foot shoulder and the turnaround.
You have certain constraints on the site.
Right.
Nobody disputes that. And whether you can accommodate the 20-foot wideway in connection with the revised plan as you've, submitted it, and accommodate the health and safety issues and do all of that,
I think we've exhausted the issue, and as you say, ultimately, the person who knows best the scope of the remand is Judge Bates.
Sure.
The bottom line, from my perspective, which I think the chair would agree with, and I think in your remarks in terms of your notice of the hearing and what you just said to the public, is that this remand does not, under any circumstances, provide a second bite of the apple to the commission or to the fire department or to members of the public to seek to re-examine or re-adjudicate issues that have already been decided by the court, other than the two issues that the court remanded, and that's the layout of the turnaround and the structural shoulder. Now, Garden Homes' response to this remand...
Before we get to Garden Homes, just to that point, the court, as to the reinforced shoulder, does specifically say that this is the last 4 lines on page 9, according to applicants, which is you and your clients, the creation of the reinforced shoulder would allow large fire apparatus 2 feet of additional driving space when entering the site, without violating the non-access highway line or the wetlands restrictions. The court urges all parties to consider this proposal on remand.
Right.
So even there, though, the court is telling us that we have to consider whether, in the context of the 2-foot wide expansion, those vehicles can enter the site
And
properly.
without being redundant, and again, to move on, given this court's holding that the 20-foot wide access way is acceptable, the court will remand the issue of the most recent redesign of the access way. The court has held that the 20-foot wide access way is acceptable. What you do with that, you'll decide. What we've done with it is, in the spirit of being responsive to the judge's request, and to try to resolve this litigation, we did, in fact, submit the material you have, which shows the creation of the pervious 2-foot shoulder area and eliminates 4 units and parking so that we could create the shoulder. I think it's important to point out also that after Judge Bates' decision came down, representatives of Garden Homes, both in 2015 and 2016, consulted with the town fire marshal with regard to the appropriateness of the turnaround that we were preparing. The reinforced shoulder required very slight changes to the plans in the upland review area of the Inland Wetlands Agency. Notwithstanding the fact that we weren't required in the judge's decision to receive any wetlands approval of the change, before returning to your commission tonight, we submitted the plans to the Fairfield Inland Wetlands Agency for their approval and verification in March of 2016. And as you know, and the record will elaborate, the finding was approved unanimously that the modifications to accommodate the turnaround and the pervious shoulder were consistent with the existing inland wetlands permit as originally approved. Now, that brings me respectfully again to the document that was submitted by the Fairfield Fire Department by Assistant Chief Bison Disson. And I know Chief McCarthy is here as well this evening. That document was dated April 2nd. We did not receive it until April 18th. There are numerous, which I won't detail, factual and legal inaccuracies in there, and we have submitted to your record for your consideration a report by Hennessy Architects PC dated May 4, 2016, and a report by Versteeg Associates dated May 6, 2016. Both Mr. Hennessy and Mr. Versteeg are here this evening should you have any questions with regard to their report. I would note, as you may be aware, that Mr. Versteeg's is the former commanding officer of the State Fire Marshal's Technical Services Division and the co-author of the NFPA textbook on site plan review entitled Performing Plan Reviews for Life-Saving Code Compliance. A couple of comments which I need to make. I was very disappointed by the comments Assistant Chief Beeson makes at page 4 of his report, which alleged,
Where are you now?
I don't have it in front of me, but it's at page 4 of Assistant Chief Bison's report.
I think it's Bissett.
Bisson, I'm sorry.
Yeah, I think so. What page?
Page 4, I believe, where he alleges that the fire department's operation division became, and I think I quote, aware of this project in September of 2015. Those of you will recall, and I think most of you were on the commission, then Fire Chief Fellner testified under subpoena at the 2014 hearing on this application and raised the very same issues, many of the very same issues, contained in the Assistant Chief's report. The project was submitted, and it's part of the record, to a code review in the spring of 2014, in which the fire department participated through the fire marshal, and the fire marshal commented in that code meeting. The record of the original hearings also established through emails numerous meetings with the fire marshal and the fire marshal's ultimate approval of the plans. All this in addition to the extensive coverage and local media attention during the time that this matter was first heard by you. So it troubles me because it seems disingenuous at best and an outright misstatement of fact at worst to suggest that the fire department did not know about this project until after Judge Bates issued his decision, or try to imply that the same concerns weren't raised in the original proceedings, or try to ignore the fact that these very same claims were rejected by Judge Bates. Having said that, we've addressed all of these in the documents that I referred to. But I am concerned because I perceive this report to be an attempt, if you will, at a second bite of the apple by the fire department that was fully aware of the original application, participated in all aspects of the proceeding with regards to that application, and would seek to widen the scope of this remand beyond what the legal authority allows.
If you're finished with that
I am.
part, I'd just like to note, it goes without saying that the chief testified at the public hearings on the matter, and clearly the fire department had opinions. They were present at that code review that you mentioned. I don't think anyone disputes that. I think perhaps even strained, but a reading of that is they learned of the need to review this revised plan after the judge issued his decision in 2015, and that accordingly they were undertaking this review as a result of that. Now, I understand that being a very, parsing the words to a very plain reading could lead you to, the reader to the conclusion that you're articulating. But I don't think anyone would argue that that the fire department was not aware of the application. So that's number one. Number two, the reason that we're here is because the court recognized that the plan as submitted was not sufficient, that the issues that were raised at the public hearing and that we found as having been an issue required a revised plan and a further review. And that's what we're here to do. The court, as you walked us through, has, at pages 8 and 9, makes that plain. And the court says specifically that, after the phrase that you keep repeating about the 20-foot wide access way, the court will remand the issue of the most recent redesign of the access way and apartment building discussed above and featured at ROR 01021 as proposed by the applicant for due consideration by the commission. So you submitted the revised plans, and it was reviewed by the town departments as we are supposed to do. And that report is the culmination of those efforts. So, I don't want to belabor the point, but I also don't want the point to be lost that there's some sort of funny issue going on, that the fire department is trying to say that they didn't know about this before 2015. Okay?
If I may respond. First of all, let me make very clear that I respect the service of Chief Hellman, Chief McCarthy, Assistant Chief Bisson, and all the members of the fire department. Having said that, I think the report, and where I quoted it, in my mind, speaks for itself. And I don't read the comments to be as precise as the chair does. Having said that, what troubled me the most about it was that if one were to assume, in accordance with your reading of it, that this report was based upon a review that was undertaken as a result of and after consideration of Judge Bates' decision, I find that inconsistent. Because the report raises wholly many issues that clearly are outside the scope of the remanded issues. And I think the report, whether intended or not, sits as an opportunity or an attempt to take that second bite of the apple. Where, just to finish the other point, where we disagree in terms of Judge Bates' decision, who will ultimately decide this, is, I will repeat what you've, given this court's holding that the 20-foot wide access way is acceptable, the court will remand the issues of the most recent redesign of the access way and apartment building discussed above and feature at ROR, etc., as proposed by the applicant for due consideration by the commission. When he, if I may finish, when he references as discussed above, he's talking about what he's talking about at the very first paragraph on page 9, that on the final night of the hearing, we submitted a sketch that dealt with an improved turnaround by the elimination of parking spaces and units. I think that's what he said.
But he goes on to explain what he means. You can't divorce that sentence from the rest of the paragraph and the paragraph that follows it, where he says the ability of fire trucks to enter and turn around in the parking lot is an issue of health and safety, blah, 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 blah. He then, at the end of the next paragraph, says the court urges all parties to consider this proposal on remand. I mean,
But then he also says, in the middle paragraph, the applicant should submit to the commission a fully engineered site plan indicating the provisions of the turning radii necessary to allow these and other large vehicles to turn around and exit the site. I think he's talking about a turnaround.
well, I mean, it's all part and parcel.
Well,
And
I don't agree.
you're taking this sentence that the Fairfield Fire Department Operations Division became aware of the proposed project after Judge Bates issued his ruling in September 2015. The proposed project that he's reviewing is the revised plan that's being submitted.
Wagner, I respect your role as an advocate, but I think you're
Advocate? I'm not advocating.
Well, I think
this
you are.
report. No. I'm trying to get to the evidence. I'm trying to get to your proposal. I don't know why we're debating this.
You have your opinion of the interpretation of the assistant chief's comments. I have mine.
It is what it is.
You have your interpretation of the scope of Judge Bates's remand. I have mine. And ultimately, Judge Bates, as it should be, will decide. You have counsel here. You have other counsel on the appeal. I know you will do as you always do, try to do a diligent job in accordance with the court's ruling.
I gotta tell you, I honestly don't really know where this is coming from, because the report that you're referencing is referring to a proposed project that is being reviewed. It's however many, 28, 30 pages. You've responded to it in the record, etc. We've just spent 15 minutes reading into the record different parts of the court's order, which plainly tells us what we're supposed to be doing. You submitted a revised plan. It has to do with the redesign of the accessway, the ability of fire trucks to enter and turn around, the health and safety related to that, the moving of large delivery trucks to do the same, the 2-foot wide reinforced shoulder. You know,
I think we're boring the public because we have a fundamental disagreement. And
I
I've
don't
said it
understand
before.
how.
The focus of the disagreement is you would have the remand, as I understand your position, to include the adequacy of the 20-foot wide accessway, which the court, to use its word, has holding is adequate.
I'm not challenging that your revised plan includes no changes to a 20-foot wide access
Nor
way.
do you have any right to reconsider what the court has already held with regard to it.
Why are you presupposing that is what we're doing?
Well, hopefully you will not. Maybe I misinterpreted your remarks. I think you have every right on this remand, from a standpoint of public health and safety, to look at the turnaround that we're proposing and the 2-foot permeable shoulder. That's what I think you have the right to take a look at. And I think,
Sure.
And I think
Commissioner Kennelly has a question.
I do, and thanks very much, Mr. Chairman. The word "you" is a little bit amorphous, and I think maybe that's something here, or unclear.
Okay.
And here's what I mean, and this is what I'd like you to clarify for me if you could, counsel. I understand in the judge's ruling to remand that this body, the Town Plan and Zoning Commission, which ultimately must make a decision, has received from him instructions what we may consider, and that is that narrow scope of the remand. That said, when you use the term you appear to be kind of using that as a broader term for the town of Fairfield. Now,
No, I mean the commission.
Oh, but if I could, you mentioned earlier, and maybe I misheard you, and I apologize, that it appeared in the report you were citing that you had concerns that the fire department officials, I think the operations division, had gone beyond the scope of the remand.
Correct.
Is it your opinion that not only must the commission narrowly focus on the issues related to the remand, but also there's something improper if indeed our public safety officials looked at your plans
Yeah.
and then went beyond the scope of the remand and may have included within it concerns? They should close their eyes to that, is what I want to understand.
As long
They
as-
should? If Judge Bates says this is the remand, fire department, now you're looking, no, you must only look at the reinforced impervious shoulder and the turnaround. That's it. And if we consider that...
The fire
we can't.
department's report
Uh-huh.
should be considered by you only to the extent that it raises issues relevant to the scope of the remand. That doesn't accuse the fire department of anything. It's just a matter of, in this legal proceeding on remand, what is the appropriate evidence for you to consider?
So anything found in the course of this process, in your view, and you're obviously as someone who's going to advocate before the judge, anything found otherwise?
Not
Well,
relevant.
just to be clear, you don't take issue with the fact that the fire department reviewed something and issued a report on something. You're taking issue with the scope of that.
And I don't even take issue as much with their scope as your consideration of what's in that report being limited to the scope of the items that are charged with you on remand.
Commissioner Barrett.
Yeah, it's more a comment than a question, Mr. Collins, but I read the decision, and I'm not an attorney like you guys are, but I do understand the issues that were raised and the decision that was made on the 24-foot access way, the request. There was a whole section about that, and it says, this represents a substantial, it has some word substantial interest, but it does not outweigh. And I understand that, that's not an issue before us. And then the second one is about, and when we were talking about that, it wasn't just about fire trucks, we were talking about intensive traffic, and ingress, and egress, and cars, and how wide a road should be for the size of that development. So it wasn't just first responders. And then we talked about sidewalks, well, that really was different too. Again, same wording, substantial interest does not outweigh. We understand that. What's back before us is the words of the reason. Now, we're having some semantical differences in terms of what that is. The only suggestion, and I have no right to suggest anything, but is if there's things in the fire department's report now that you think is beyond that scope, you could just highlight that and what they are. I think that would be okay. Obviously, you think that, and I would like to actually hear the presentations of the applicant and the fire department to be able to weigh that.
We've submitted reports, as I said, by Mr. Versteeg and Mr. Hennessy. I think they address that,
Okay.
because even though we point out in those reports that there are numerous items that are beyond the scope of the remand, we do, as a matter of courtesy to the department and to this commission, respond to all those points.
Right. And you know, look, the reason that the court is requiring us to consider a revised plan with a turnaround is for health and safety reasons.
On the turnaround, I agree.
Okay? I mean, if it wasn't for health and safety reasons, there wouldn't need to be a turnaround. So we have to consider whether the inclusion of that turnaround is adequate for the purpose that it serves, which is namely the health and safety of the building, the residents, etc., and so that whether the fire department can do its job when it's on the site and so forth. So, you know, I think
we end in reasonable consensus. As long as that analysis that you've just described is focused on the turnaround.
Well, you know what, in some ways, I've got to hear the evidence. I mean, I got to hear what
I'm
people
gonna
have to say. But, you know, if there's a turnaround, does that mean that there, you know, are other issues that are affected by the way that it's been laid out? You know, you put it in a certain place. Is it an appropriate place to be put? Does the placing it where it is and how it interacts now with the rest of the site layout affect how other things get done? You know, that's what part of the fire department's report assesses.
If your analysis is focused in those manners on the turnaround, then I think you should hear the evidence, you should make your decision, and then the court will decide. I have no quarrel with that. My overly lengthy remarks, perhaps, were just to focus our position in terms of the jurisdictional components of what's before you tonight. Sure.
I mean, I appreciate that. Now, you know, listen, we frankly may not be that far apart after all of this, but you know, we can't simply divorce health and safety and the purpose for the turnaround from the sketch on the piece of paper, you know, the actual lines on the piece of paper. I mean, the court's remanding this to us for a purpose, for a reason.
To review the turnaround and the shoulder.
So
maybe as Mr. Barrett said,
There you
it
go.
was a matter of some semantics, but if we're focused on the turnaround and we're focused on the 2-foot permeable shoulder, then we're in consensus. I thank you. I think what I should do, in fairness to the commission and for the record, is ask Mr. Trinkus, our engineer, just to briefly review the aspects of the plan with you, so you'll have some overview of that as far as the shoulder.
So just to be clear, what is your plan for your presentation this evening?
I'm just going to have Mr. Trinkus present a very brief overview of our plans for the turnaround and the 2-foot pervious shoulder. We have both Mr. Hennessy and Mr. Versteeg here. They're available to you for questions. Depending on any comment or testimony that we might hear, I would reserve the right to call them to rebut.
Okay. They're not planning to make any independent
In
presentation?
fairness to the commission, I know how diligent you all are. I'm sure you've read their reports. I'm sure if you have questions about their reports, so why should I have them read the reports to you?
Your prerogative.
Good evening. For the record, my name is Stephen Trinkus. I'm a consulting engineer with an office in Southbury, Connecticut, representing Garden Homes. I too will apologize for the spring allergy voice. The site plan, I'm going to show you
You guys both went to the same place last night.
And it's all, yes, we have. This is sheet 2 of 9 with a date of March 18th, 2016 of the plan set. The 2-foot permeable shoulder, I'm tracing with my finger, which comes in from Bronson Road to this point. At this point, it stops because we have a drainage swale. Where we get near the building, the shoulder goes on the opposite side of the driveway. This is the location of the 4 parking spaces that were eliminated. It is to be kept as pavement and striped with painted fire lane for that. On sheet 9 of the plan set, I looked up on the town website the specific aerial fire truck. I then contacted the manufacturer, and he provided me with the specifications of the truck and the turning movements. And what we have on sheet 9 of 9 is the 4 movements of the aerial truck being here, a backing movement up, then a pull forward movement, a second backing movement, and then a 4th movement forward, which aligns him on the driveway to head out, so he is not backing out of the site. So it's 2 turning movements, and he goes from pointing in to pointing back out, and he can drive out the driveway. Now, the permeable shoulder, a standard bituminous curb is 6 inches in height. Along the edge of the permeable shoulder, we're going to use what is commonly called a Cape Cod curve. It is a low curve, depending on the asphalt contractor, it's 2 to 3 inches in height, and it's rolled, so it's not kind of an abrupt curve. So it's easily mountable by a vehicle. On sheet 9 of 9, there is a detail of this section. Under the road, the driveway itself, there's a 12-inch gravel base and 3 inches of pavement. For the permeable shoulder, we have a 15-inch gravel base and 2 inches of topsoil on top of it. So we basically have a structural lane that's all grass. It's no different than the original plan, which had a grass shoulder. The original grass shoulder would have had 4 to 6 inches of topsoil because it was just going to grow grass. This provides an area that will grow grass. It will also, if the fire department ever needs to drive over this, they can drive over it and not sink out of sight because you have a structural base under the material of 15 inches of gravel. And that's the explanation of the 2 changes.
Mr. Chairman, a few
Yes,
questions.
Commissioner Macklin.
Just a couple of minor clarifying questions. So that detail that you just described for the...
Yes.
Is also in front of the building, is that correct? Towards
Yeah, exactly.
back edge?
It's off the, on sheet
Like on the north side
2
of the
of
building?
9,
I guess
it would
is?
be the, yeah, I guess it would be the northwest corner.
Okay.
Off the northwest corner.
So that's going to be a grass strip in front of the building?
Along this side of the driveway, that's correct,
Right.
Mr. Chairman.
Okay, and then, in drawings, what you label the movements 3 and 4, especially movement 4, it appears that the fire truck, the rear of the fire truck would be 6 inches from the back of the building, the way it's shown there, as it's backing up. I mean, it looks a little tight, so I don't know.
It's within a foot, but also these were taking the conservative movement that the manufacturer provided for me. As the turning wheels on the fire truck are up front, as you back up, you can turn much sharper than what we're showing here.
Okay.
So the movement, this is a very conservative movement using the defined radiuses of the manufacturer. In reality, they can back up a much sharper angle than we're showing here. So then you will not be as close to the building in that scenario.
Okay, give me 1 second, sorry. Let's see. And then also, well, I guess all the action for the truck is going to happen in front of the building. But again, at that same spot, the clear elevation on the garage on that, which would be, I guess, the south portion of the building, is 10 feet. The truck is 11, 9 and a quarter. So there's no provision for them going under the building at all whatsoever.
No, the
It's all in front
southern
of the
portion of the building is 13 foot. It's 13-foot clearance here, this is 10.
I must
So,
have been reading the wrong elevation. I thought it was the other way around.
yeah,
It's-
no, I think,
Yeah, I think the south part of the building is 10 and the north is 13.
well,
I would just be concerned that,
I'll ask
Does
Mr.
that seem
Hennessy
correct?
to address that.
Am I reading it?
Andrew Hennessy with Hennessy Architects. Looking at the site plan, this driveway has a clear height of 13.
right, and then the lower one is 10?
This one here is 10 the whole way.
Okay, so there's no way the truck could go under. It looks like it gets close to the building, but I understand what you're saying, that it could be, now my bigger concern though is if you look at the topo, it would have been handy on these movements if the topo was shown. In that fire lane, no parking section is a 4.5-foot change in elevation. And can the truck doing a, whatever that is, 60 to 30 to 45-degree turn at various times also handle that kind of change in topography?
You're seeing the existing contours here, that's not the proposed contours. We did not, on sheet 2 of the plan set, the proposed grading is not there. That is virtually level in that area, that's about a 2% grade or flatter. So
It looked
what
to
you're
me-
seeing here are existing contours, and those are being changed, it's made flatter in that area. There is a grading plan, I don't know if it's sheet 3 or 4.
I'm looking at, I don't see a sheet number. That first drawing you showed us, I think, doesn't that show it going from 21 down to, right, am I reading this wrong? Looks like it's going from 21 in this upper corner down to almost 18 or 19, almost 17 in the zone it would have to turn.
That's existing, if I may.
That's the existing? Oh, I see. Sure.
Yeah.
I'll turn this around. Well, while you're doing that, I'll just add that. My concern was that on the one side, on the south side where the new fire zone is, I read it as a 4.5-foot change going east-west, and on the north side, almost a foot change. Clarify.
Yeah, to clarify, on the southern end of the fire lane,
What sheet are you on?
this is sheet 3 of 9 of the plan set.
Thanks.
The proposed grading are roughly from 18 to 19. It goes up as you go to there's a spot elevation 18, 18 and a half, 19. Across the way is 17 and a quarter, so you basically have about 1.25 feet across that, so
That clarifies it
almost
for me.
level.
Perfect, thank you. No, that's it for me, thank you, Mr. Chairman.
Yes.
Mr. Trinkus, I don't know whether this is a question more properly addressed to you or to really anybody on the team there. In my mind, I'm imagining a scenario where there's a significant fire or perhaps an explosion. And is your assumption as far as emergency access predicated on none of those 95 units getting in their cars and exiting the property, fleeing, in other words, at the same time that an emergency vehicle would be approaching? And does the driveway, even with the 2-foot pervious strip, make allowance for massive traffic exodus at the same time as the emergency vehicle is approaching?
I think I'll have Mr. Versteeg address that because that's much
Thank you.
beyond my civil.
For the record, Joe Versteeg, Versteeg Associates. Yeah, the 20-foot requirement of the Connecticut Fire Prevention Code for the lane width does take into account for vehicles passing in opposite directions, as well as passing each other while one is stopped. So there's more than enough room for vehicles that are egressing initially. Of course, once the fire department's on site, the egress of vehicles will stop.
My concern would be the fire department would never get on site because I doubt that the vehicles attempting to exit would necessarily stick to one side and make room for the other, for the fire truck approaching.
Well, I think you'll find
And if
that,
they pull off entirely, then they just sink into...
yeah, I think you'll find historically that when the alarm goes off in the building, the motivation of people within the building occupants is to leave the building and then stand around and see what's going on. Is it really an alarm? The last thing they do is get in the car and, oh, I have to protect my car, and leave.
Isn't some of the parking underneath the building?
Yes, it is.
So wouldn't the people with their cars at risk at least want to get out?
I don't think historically we haven't seen that desire to do so. There's that initial, what's going on? Is there a fire? Is there an emergency? And the reaction is once they realize that there is a fire, it's to physically move themselves away from the building and not so much protect the car or go save the property.
At page 8 of Judge Bates' decision, he actually discusses the testimony that was heard with regard to the NFPA standards concerning the width and the single access way. And again, without being redundant or disrespectful, I would point out again that this gets to the point I'm most concerned about. the access way, we had, I think, 4 or 5 nights of public hearing with regard to this initial application.
Yeah, you might want to pull that up a little
And,
bit.
and the adequacy of the width of the access way and the propriety of having only one access way was a very fundamental issue. And Mr. Versteeg testified, material was submitted, Chief Beltner testified. At the end of the day, the court has ruled on that.
Other questions for Mr. Trinkus?
Thank you.
Okay. Thank you, Mr. Trinkus. Yeah, we get a little copy this time. Mr. Fallon?
Yes, sir. For now, subject to any relevant rebuttal comments, we would offer nothing else.
Okay, we have the materials that were submitted. Thank you. So before I turn it over to public comment, sorry, these plans are a little large. Thank you for the big plans. Before I turn it over to public comment, as you've heard, we did have a review of the revised plan done by the fire department, and we have here tonight Chief McCarthy, who I think has some remarks that he'd like to share with us.
Thank you. For the record, I'm Dennis McCarthy, Fire Chief, Town of Fairfield. To put this in context, in regards to the analysis that the department undertook and referenced in the submission from Assistant Chief Scott Bisson, I felt it was our responsibility to look at the entire scope of the project as it relates to access to the property, and do conditions in and around the site influence our need for access to the property. In the development of that report, we looked at all of the factors. We looked at the proximity of the property to I-95. We looked at the proximity of the property to Metro North Railroad and Amtrak Railroad. We looked at the proximity of the property to a chemical processing plant just on the other side of the Metro North right-of-way. We looked at the property as it relates to the flood zone and waterways and access or egress ways for residents to flee on foot, to your comments, Commissioner. How do people leave when there is an emergency? How do they protect themselves in place if there was a chemical emergency, either on I-95 or at the Superior Plating? So we looked at the entire scope of the project to truly understand to what degree we needed to advocate for improved access. Because all of those conditions do affect how the fire department responds and how it reacts to an emergency, and the type of equipment and the speed in which the equipment would respond. So we did have significant concern about the size and scope of the project, our access to it, and the ability for residents to flee should there be an emergency. And I'm pleased that as a result of that submission, we have received word back that the property will be protected with a full 13D sprinkler system, which is different than what has been installed in other garden home projects, particularly Fairchild Avenue, which is a residential sprinkler system that doesn't fully protect the entire building. There are some smaller spaces in the building that by code are not required to have a sprinkler head.
That's different
Small
from...
closets and bathrooms in particular.
Is that different from what was originally proposed in the first place?
I was not aware of a specified fire protection system in the building.
Okay, I mean, because I know
Whether
that-
there was or not, I was not aware that...
Yeah, I know that the original plan had a sprinkler building. I mean, that was a key part of their argument with respect to the single access way.
And I can't tell you whether that was a 13D or a full 13, a 13R or a full 13 system.
Okay.
So we did the entire review, and the response to our submission, the most recent one by Assistant Chief Scott Bisson, was that there will be a full sprinkler system in the building, and we're happy to see that. However, as fire chief, I remain concerned about the project, and I am concerned due to the type of construction, the proximity to significant hazards, as I mentioned, I-95 Metro North railroads and Superior plating. These hazards, combined with the size and density of the project, as well as the configuration of the site, create hazards and risks to the resident population. Those risks could be minimized by separating and segregating the access and egress from the site. Properly designed, the residents could evacuate and escape the potentially life-threatening emergencies, while the fire department personnel could access the property promptly, safely, and efficiently. As currently proposed, the project creates a fire department access condition that, in my opinion, will significantly impair the fire department's ability to respond to a fire or an emergency in the facility. Please, if you imagine a fire alarm activation in the development that by design causes 100% of the population to evacuate. Those evacuees have no place to go, no place to assemble that does not interfere with fire department operations. This is not an urban setting where there's a Starbucks down the street, a library or a mall, a place to go to get out of the weather to protect yourself while the fire department operates. We're asking them, when that alarm goes off, to leave the building. We are sending significant, and you saw in some of the diagrams that we submitted, significant amount of equipment that takes up the entire asphalted parking lot and access way.
Including the turnaround that has been proposed.
Yes. So there is no place for residents to go that does not interfere. And it is my experience that residents will try to get away from the property, particularly if they expect they're going to be trapped there without their vehicle for a very long time. They will
I don't want to interrupt this.
Right. Are you?
So I have a couple pages and...
Please go. Please finish. I do not want to interrupt.
So we expect that the residents will attempt to flee, and they'll attempt to flee in their car. Those cars that are underneath the parking garage, they'll try to get them out to protect their investment. Fire apparatus that are responding, and we send a half a dozen pieces of heavy equipment to respond to an emergency here. Fire departments that respond will meet heavy traffic leaving the site. The single access road cannot accommodate 95 cars leaving as a half a dozen fire apparatus arrive. As a result, the fire department's ability to intervene and resolve the emergency will be delayed and impaired. The presence of a sprinkler system does not minimize or alleviate the fire department need to respond. There are a number of scenarios that can jeopardize life in a sprinkler department building. These include fires that are deliberately set, fires in automobiles around and under the building, which generate significant amount of smoke, and smoke from a fire in a living unit that disorients and overcomes residents. Sprinklers may control the spread of fire, but do not typically extinguish it fully. The fire department's need to rescue and evacuate residents and to fully extinguish the fire. Sprinklers are not always effective in controlling a fire due to deliberate or other factors that allow a fire to overwhelm the system. The National Fire Protection Association Uniform Fire Code specifies, and I quote, "More than one fire department access road shall be provided when it is determined by the authority having jurisdiction that a single road could be impaired by vehicle congestion, condition of terrain, climatic conditions, or other factors that limit access. It is my professional experience and practice to request or require, when I can, multiple avenues of public safety access for large facilities. The reasons are that over the lifetime of the building, which may be 50 years or more, that it's likely that multiple responses by the fire department will occur every year. Since June of 2014, the Fairfield Fire Department has responded 14 times to the Garden Homes facility at 130 Fairchild Avenue in Fairfield.
How many was that?
14. Those 14 responses included a structure fire and a total of 6 other incidents that required full evacuation of the apartment building. The Fairchild apartments have a total of 54 units, as compared to the 95 units that are proposed at the Bronson roadside. Given this history for a similar project in the same community, same demographics, we could expect 24 calls for service over a similar period of time, or roughly 1 call a month. This makes our concern very real. This is not imagined. This is not theoretical. When the proposed building is evacuated, there's a real concern for the safety of evacuating residents and a serious problem for fire department access to render aid. It is my responsibility as the fire code designated authority having jurisdiction to act on behalf of public safety as well as the safety and the efficient operation of the fire department. Exercising that code responsibility, I request the Commission to deny the approval of this project until and unless adequate fire department access be provided that is not impaired by vehicle congestion and other factors that limit our access.
Thank you very much. Commissioner Barrett?
Yeah, if you don't mind, Mr. Chairman, I have a question for Chief McCarthy. First of all, thank you for being here, and thank you for your service, your department, and everything you do in this report. Again, you're probably not an attorney either, so, you know, remand and this stuff, but as I read this court decision, there's a section called D. The other sections, as Mr. Fallon and Mr. Wagner talked about before, those are the ones that were reversed, or just reversed. Section D talks about, the title of it is, and this is the judge's title. Sorry,
No, I turned it off so I wouldn't make a lot of noise when we were whipping around maps, so I apologize for that.
Did you want to go back and thank me again?
I want to thank you.
Just for the record.
Yeah, so Section D, the part that we are here for, I think everybody agrees, I mean, that's the section you read, is titled, Lack of a Second Access Way to the Apartment Building. So I view as what you're dealing with is there is still a lack of a second access way, so I think your report covered a lot of the, consequences of that and the revised plan. So I just want to ask you about something that's in the report. It talks about site access procedures. This is maybe touching the third whale because it talks about 20 feet, but I'm just going to read you something here. It says, due to the configuration of the site, the department also requires wider access than the minimum 20 allowed by portions of the fire code. So we're recognizing what the fire code allows for the safe operation of the fire apparatus. The positioning of the roadway against the side of the building places it directly in the collapse zone of the building, placing apparatus and personnel on them in harm's way from debris, broken glass, and direct fire impingement. And, later on, it goes to talk about building access, and that, there are significant access problems to the building for firefighters and apparatus. The location of Site A is too close to the building. So, could you talk a little about that? You're saying it's not just generally that we'd like to have a wider access, is it this project, this plan, this access, how everything is situated with the building, does not allow for safe operations, is what I would say.
Right. And there is limited code authority for me to influence that, quite honestly. And however, we included in our evaluation of the project to make a decision whether we needed to advocate strongly for improved, over the proposal, improved access to the site. If all of the other conditions are out of our control, that the code does not allow us to require that you don't park cars right up against the building, which prevent us, one, from laddering the building with ground ladders, and two, introduces a fire hazard right up next to the building. When I talk about factors that can overwhelm a sprinkler system, A auto exposure, a fire climbing up the side of the building from a car parked right up against the building is one of those factors. The fact that we cannot access the full perimeter of the building. The code doesn't say that we have the authority to require it. We are not driving underneath an overhang and potentially risking a piece of equipment on the far side of the building. There is congestion on that site that requires it. You think of the Fairfield Fire Department. We have a fire station in Southport that's going to respond, a fire station in Greenfield Hill that's going to respond, and a fire station on Reef Road that's going to respond. The configuration of the site almost dictates that we ensure that the right piece of equipment arrives first, and if it doesn't, that it waits for the right piece of equipment to access the site so that the ladder can get in to provide ladder operations. This site presents so many challenges for the fire department that it raised that level of concern that I felt it important to detail all of those concerns for the commission so you understand how we approach this building and why access, if the only thing that we have in our toolbox to make the situation better is to ensure that we can get everybody in while the people are getting out, then we are going to advocate for that better access.
Thank you.
Commissioner Kennelly.
Chief, thanks for your service. Regarding the turnaround, we heard a testimony from the applicant's expert regarding what they described as a conservative view of how your apparatus would be able to maneuver in the turnaround. You, in your testimony, talked a little bit about the kind of troublesome conditions in terms of there's nowhere for folks to go, they're going to be interacting with apparatus. Can you give me perhaps an understanding of whether that description of the vehicle's ability to operate in the turnaround conservatively, it's going to be fine, or are the real world conditions you're likely to face in an incident ones that impact turning radius, multiple vehicles, people on site, weather conditions? Are any of those factors as well when I have to consider how safe the new turnaround or the proposed turnaround would be?
I'm of two minds regarding the turnaround. One, if we're just leaving the site, how long it takes us to turn a piece of equipment around is the least of our problems. However, when you consider that we may, and historically using averages from the other development, that we may be responding there once a month, it becomes a greater concern. Having 4 turning movements in order to turn a ladder truck around is a lot of jockeying of a heavy piece of equipment, and you won't be surprised, or maybe you will be surprised, that there are a number of firefighter deaths run over by backing equipment. It is a dangerous operation. It's difficult for the driver of a 50-foot long vehicle to always have visual contact through his mirrors of the person that's directing them to come back or to back up. So the fact that this is a very cumbersome operation, I don't think it is one that when you look at the diagrams in the handbook that describes turning movements, I don't think that it anticipates the amount of turning movements that is being proposed in this. That said, it is not the most important part of our issue. Certainly, it is one of those, but maybe it's not as critical as accessing the building with the right equipment and being able to fight a fire there.
So, your review of the revised access way and the proposed turnaround had to take into account the totality of the circumstances. Is that what you're saying?
Yes.
So, your review of the revised access way and the proposed turnaround was not just limited to when trucks have finished doing what they need to do and are merely trying to turn around to exit the property, right? And you had to think about the revised access way and the proposed turnaround as being in operation during an event, when you're on the property fighting a fire and doing your job, right?
Correct.
So, and I want to make it clear because, you know, your report is very comprehensive and it covers a lot of ground. But I would like to know whether, in your professional opinion, does the redesign of the access way and the apartment building, along with the proposed turnaround, enable the fire department and the fire trucks to enter and turn around in the parking lot to protect the health and safety of the public and the occupants of this building?
No, it doesn't.
Thank you.
Mr.
Yes.
Chairman?
Commissioner Coleman.
It never occurred to me before that there would be 3 fire departments responding, and you're right, based on where they are, just that light bulb never went off before. Do they all have fire?
Quite honestly, a structure fire in an apartment building would get the entire deployment of the Fairfield Fire Department. For manpower and equipment, we would send all 5 stations and 7 pieces of heavy equipment, as well as Southport volunteers to participate in that effort.
And is there one ladder truck?
There is 1 ladder truck and 1 rescue truck, soon to be a ladder truck and a quint, which is a pumper with a ladder on it, but we'll have 2 ladders on scene. We would most likely call mutual aid from a neighboring department should the fire grow in size,
Right.
and to require that.
Can you see 3 ladder trucks operating on a fire on that property?
You can't get 3 ladder trucks to operate on that. You know, I don't know how you would physically accommodate that. And you know, if a fire overwhelmed the sprinkler system, certainly it would be preferable to have access to any type of piece of equipment that the incident commander on scene feels necessary. We don't have that capability here. What you get on that first alarm, it is what is going to be up against the building, and there is very little option and maneuverability. No one's turning a fire truck around on that turnaround under emergency circumstances. That is not happening. It's unrealistic to think that it have any application while the emergency is occurring. That is after the incident has been resolved. So we don't have access, we don't have the ability to get additional specialized equipment should we need it to the scene because of that single access point.
And part of the issue would be subsequent emergency vehicles that are backed up behind. You said the first one on site, he gets there, and then the others have to wait in queue. So
They're not moving.
other ladder
Right.
trucks would be blocked by other emergency vehicles ahead of them. Thank you.
Mr. Chairman, quick question?
Commissioner Francis.
I was concerned about,
Got to use the microphone.
I was concerned about the collapse zone for a 3-story building and with all the fire equipment on site. Could you discuss that a little?
So when we look at the building, the fact that we are really limited to positioning equipment very close to the building. There is you look as you drive in past the parking garage entrance, you swing to the left and there's parking on both sides. Some of the cars are right up against the building, some of the cars are up against the curb facing the wetlands. There's a 24-foot wide space there. That 24-foot wide space is 15 feet from the edge of the building. Anything that occurs in that building could jeopardize that piece of equipment, and we have no maneuverability. We can't move it, we can't get further away. So there is a philosophy or a tactic to never jeopardize a piece of equipment that could be affected by a failure of the building.
Seems extremely dangerous. Thank you.
Commissioner McAleese?
Thank you. Chief, the reference truck, is that the largest piece of equipment we have in
Yes.
town right now? But
Yes.
you mentioned something soon to be, is that it?
No, it would be smaller than that.
Oh, okay, I just wanted to be sure. And maybe this is a naive question, but who covers something like that? If the building collapses on our equipment, is the building owner, the property manager responsible? Does our town insurance cover that?
It would be town insurance.
It would just be the town's?
But I will leave it to the lawyers to fight that out after the
Okay,
fact.
thank you.
So another question that the court asked us to look at is whether the creation of the reinforced shoulder would allow large fire apparatus 2 feet of additional driving space when entering the site without violating the non-access highway line or the wetlands restrictions. Did you have an opportunity to take a look at that?
Yes, and I think that for the reasons that I have detailed, a single access way will be congested with residents fleeing at the same time as fire department is arriving, and that the bottleneck that will be created will limit our ability to access the building with equipment and manpower, and hamper our ability to do what we're charged, our mission is to save lives and protect property. I don't see the additional 2 foot of space as resolving that issue for us.
Is that because you're considering this fact pattern sort of during an event? You know, when you're first called to the site and there are people trying to leave and fire trucks are trying to come in. Is that right?
Correct. And this issue of people leaving, I think this is a very peculiar circumstance. There is apartment buildings, the Fairchild Apartments on Fairchild Avenue. There is ample public roadway, sidewalks for residents to leave, to escape the immediate footprint of the emergency, and take shelter in commercial occupancies that are nearby. They are in a commercial zone. They can call, get a ride, get away from the building, and find a place for shelter while we operate at the scene. We're not talking about that same type of environment on Bronson Road. If they leave on foot, they're on Bronson Road. By the on-ramp to I-95, there's not a payphone, there is not a commercial entity there that they can, get out of the snow, the rain, the wind, cold, heat, or just make a phone call to get some help.
Do you know whether that problem that you foresee entering the site relates to the non-access highway line or the wetlands restrictions? I mean, are those 2 the problems? I need to focus on that. If you didn't specifically look at the non-access highway line or the wetlands, one or the other or neither, just let me know. But the way that this is laid out, I'm gathering from what you're saying that if the fire emergency apparatus is trying to enter while folks are trying to leave, somebody's got to give way, and that give way, does that give way over the non-access highway line or into wetlands areas?
Yeah, in our review, we expect that people leaving, whether by car or on foot, will use the roadway. That they can't go south because of the Metro-North Railroad. They can't go east because of the river. and the brush, the wetlands, and under all weather conditions, it's unlikely they would try to make access through the woods out to I-95 or that on-ramp. That, I would expect that human behavior would suggest they'll go out the way that they came in, and that's by the roadway.
Well, just to be clear, there is no other entrance or egress from the property that is designed for
Oh, you're talking
foot
about
travel
roadway.
or for vehicle travel, other than the proposed access way, right? Conceptualizing the footprint of the
Right.
property in the plan, you've got, wetlands, a pond, and Metro North Railroad. The only way in and out is on the proposed access way.
So is your question, did I look at other options for a roadway?
Well, I'm going to get there,
Okay.
but what I'm focused on right now is the specific question that we've been asked to look at, which is whether the creation of this reinforced shoulder, this extra 2 feet that they've provided on the access way, would allow large fire apparatus, when entering the site, to avoid violating the non-access line or the wetlands. And that's as kind of fine-tuned as I can get it, right? So I'm imagining you've got cars coming out, fire trucks trying to come in, somebody's got to give way. They're going to go off to the side, I'm hearing you say, one way or the other. Is that going to violate the non-access highway line or intrude on the wetlands? That's really the question.
I can't answer that question.
Fair enough.
I don't think I have evaluated that to give a competent response.
Fair enough, and I appreciate that. So now I wanted to get back to my earlier question, which you did comprehensively review. And part of the reason why I got to the nugget of that last question was because it wasn't something that was clearly articulated in your report. And what you did clearly articulate in your report was your review of the ability of the fire department to do its job and fight fires on the site given the proposed plan. And your answer before was that you couldn't, based on the proposed turnaround and the redesign of the access way. My question is whether you could conceive of any other types of modifications that would enable you to adequately do your job, move around the parking lot, and fight fires and protect the public health and safety of the public and the occupants of the building. So I'm trying to move just one step beyond what they've now proposed and what you've told us is unsafe. Can you envision an alternative plan that would enable you to do that, given the confines of, the layout and the plan?
I think that the fact that a single emergency is causing the evacuation of 100% of the population creates this challenge for us. And if this was, and we have reviewed other developments in town that are currently in development or in design that have limited access but are in individual buildings, so that a single emergency may require the evacuation of 4 families or 8 families. And that environment now provides an area of refuge for those 8 families while the fire department is responding. And we don't have 95 families dumped into the parking lot and interfering with fire department operations. So the only way that I can see, because obviously there's a real challenge finding another way to get an access road in, the way to approach this, and I'm not a designer, engineer, or an architect, but the way that my experience has been, and that the way that this is resolved, or the impact lessened, is by having living units that are smaller in size and capacity, so that one emergency doesn't affect the entire population on site simultaneously.
So are you talking about just a smaller apartment building, or separate units? Just a smaller scale?
Well, if there were separate units, that, we have a project going on in town, it's 8 individual buildings that are being built, that are, 4 families in each or so, I think as many as 8 families, that, it has the same access issues, but we're less concerned because of the impact the impact on the entire population is not simultaneous.
And that's a proposal here in the town of Fairfield under Section 830G that we just approved, that's now being built. Is that the one you're referring to?
Yes. You're talking about Pine Tree?
Right.
Yep.
Right. And so you reviewed that site plan and the fire safety, on that plan, and it's your opinion that one is safe because there are separate dwelling buildings and larger areas for the fire trucks to come in and move about.
And we did ask for a second means of egress or access, but what was proposed in alternative was a turnaround so we can get out. But the main issue in that is the size of the units we felt were within our ability to respond effectively and efficiently.
Commissioner Barrett, yeah. No?
Yes, Chief McCarthy. I'm sorry,
Use your microphone.
Turn this on again, I apologize. What's the AHJ? I'm going through here. What does that stand for?
Authority having jurisdiction.
Authority having jurisdiction.
And
you,
in the fire code, in reviewing plans, it's typically, or for the purpose of the fire code, it is typically the fire marshal. But the handbook lists a number of people, depending on the subject, that could be the authority having jurisdiction. The building official being one, and engineers or architects being others. So there are a number of professions, depending on the subject, that could qualify as the authority having jurisdiction.
Okay.
I am the fire chief. I'm responsible for fire suppression in the town of Fairfield. I am the authority having jurisdiction as it relates to fire department access to the building. The fire marshal is the authority having jurisdiction as it relates to enforcement of the fire code design and enforcement.
that would be things like the sprinklers and things like that.
The layout of the exit ways and things like that.
Okay, right. That's what I thought. So in the department's report here, again, it talks at the end about operational needs. And again, the reason why we're here, the remand, if you is a section in the judge's decision that talks about the lack of a secondary means of egress. And it says here in your report, in your department's report, the department requires a second access egress roadway from the site to allow fire apparatus in. Talks more, and this is the Fairfield Fire Chief, that would be you, serving as AHJ, has determined that more than one access road is required based on hazards and factors documented in the report. So that is the position of the fire department, that still, after reviewing the secondary thing and looking at a turnaround, not, question other things, you've determined that your department, that the turnaround proposed is not sufficient, and that you still require a secondary means of access and egress to allow to enter and leave the site safely.
Yes, and I think that I am authorized to make that requirement based on the code section that I quoted.
Right, because again, I don't mean to jump ahead to the applicants. I don't know if you recall a rebuttal in the situation, but just response.
It is, and I think it's important that if because you have the report.
Yep.
And Chief McCarthy is here now, and if there are questions that we have about the applicant's rebuttal for
Yeah.
Chief McCarthy to respond to, I think it important
I
that
do-
we ask them
okay.
now, because, you know, I don't want to be
Can't ask
coming
them,
back
yeah.
up and back and up and back, right? And
Okay.
so he's got his opportunity now, and if there are things we want to ask him, we need to ask him now.
Okay, good, so then that helps me out. And I just apologize, I'm going a little slow, I'm trying to, go through some, details here and making sure I lay this out correctly. But you are the AHA, and you've determined that more one access road based upon hazards and factors documented in the report, and you talk about a single road could be impaired by vehicle congestion, condition of terrain, climatic conditions, and you are the person that is authorized to make that determination. In the applicant's rebuttal, and it's a thick report, and I'm not putting it down, I think it was laid out well, but this report by the applicant is really the fire department's report with responses.
Right.
Which I think is good, it actually allows us to do that, but after that statement, it says that the fire code handbook supports that, clearly identifies that the requirements of a second road consider other factors, and it lists some of and none of those are present. But would you still say that you've looked at the other factors, the condition of the terrain, the climatic conditions, the layout, the site specific, and just based on the totality, as you word, of the totality of the plan and the turnaround, determined that the turnaround is not adequate and that you would require second access egress?
That's correct.
Okay. I know I said a lot that was just in your report. I just want to make sure I understand. And you're the authority having jurisdiction to do
Yes.
so. Okay. Sorry. You have anything else to add to that? Again, I'm trying to read the report and the rebuttal, but the rebuttal just says there's other conditions and these conditions don't apply, but you've still made that determination here.
So there is in the handbook some reference to if there's a railroad tracks. Railroad tracks cross and block that single point of access. As an example of a condition that the authority having jurisdiction would, in that circumstance, be compelled to require a second means of access. Doesn't limit it to that.
Right.
And the code language is specific. It says, when the single road could be impaired by vehicle congestion. There is no doubt in my mind that an emergency, when a similar facility right down the street of the same developer has been evacuated 6 times in 2 years and had a structure fire, there is no doubt in my mind that we will be there repeatedly when the building is completely evacuated. And I don't think it's a stretch to expect that those residents are going to interfere with fire department operations. I don't care where they go. They're my responsibility. Once they leave that building, they are my responsibility. Whether they go into the marsh, they go to the railroad tracks, they get in their car, they're still my responsibility. We have caused them to be evacuated. And I don't have the ability to protect them while I'm responding and to ensure that their safety. They leave the site. They're milling about on Bronson Road. The town still has to provide them a degree of safety and protection.
I'm sorry to interrupt.
I'm done, go ahead.
But you just made me realize something, I think, that the entirety of section D here on page 8 is talking about the lack of a second access way. And I think that in part what the court is trying to have us review is whether the provision of this turnaround is sufficient to accommodate for the lack of a second access way. And it's your opinion that that is not the case.
I'm not sure that
So, the court says, and I don't want to argue too much of the court opinion, but the court says, given the court's holding that the 20-foot wide access way is acceptable, because earlier in the opinion the court has a separate section, it's A on page 4, that deals with its decision on how wide the access way should be. And at the end of that section, it says, well, talk about 24 foot, you talk about 20 foot, there's different authority. We think 20 feet is fine. Then the court gets to page 8 in section D and talks about the competing testimony about the lack of a second access way, which is in some ways the crux of what you're talking about. It then goes on to summarize some of the competing testimony that was presented. The applicant saying single access way is fine, the commission arguing that in our decision that we needed a second access way, in part because the trucks can't turn around and they can't get out. So the court remands and says there was a redesign with this turnaround, so you commission need to look at a revised proposal that provides a redesign to the single access way, including this 2-foot buffer, and the proposed turnaround, and make a decision as to whether or not those are sufficient to accommodate the lack of a second access way, which you have told us prevents the fire department from doing its job and protecting the health and safety of the public and the occupants of the building. And so, while a 20-foot access way may be sufficient, it's your opinion we need 2 of them. And it's your opinion that if we only have one, the proposed turnaround on this revised plan is not sufficient to accommodate only one access way. Is that right?
That's correct. The turnaround does not improve fire department access to the building. It does not resolve the issue of access. In fire department operations, the turnaround is the last operation we will conduct on the site after the fire is put out. It is irrelevant to the issue of fire department access.
Well, because there are 2 things here. I mean, the court is telling us we need to consider the redesign of the access way, the apartment building, the shoulder, and the turnaround. And it's tasking us with deciding whether this revised proposal provides the ability of fire trucks to enter and turn around in the parking lot as an issue of health and safety. And what I'm hearing now is that you're saying it's not, but in part it's not because we only have one access way. So that turnaround is insufficient and is
not a suitable alternative to a second means of access.
Thank you. Thank you. So not only is it a problem, it's really two parts to it, right? Not only is it your opinion that it's a problem during an event, it doesn't provide the ability for trucks to enter, turn around, and do what they need to do during an event, but it's not a suitable alternative to a second means of access.
Right.
Anybody have anything else?
Thank you.
Thank you very much, Chief. Is there any member of the public that wishes to be heard on this?
Good evening, Mr. Chairman, members of the commission, staff. My name is Joel Green. I practice law in Bridgeport, the law offices of Green and Gross. It's my pleasure to appear before you this evening on behalf of the Lower Bronson Neighborhood Association. I had appeared before you on behalf of that association on the original application in this matter. I was wondering, I think it would be helpful to the commission, and I'd like to ask through you, Mr. Chair, if it wouldn't be appropriate to just ask the chief to highlight some of his education, training, and experience in the area of operations. I note that the commission asked a number of questions on that, and I think it would be good for the record
That's fine.
to include that sort of material, and I'm wondering if
And you may have just said that, yes, and you may have just said this, but who are you here representing tonight?
the Lower Bronson Neighborhood Association.
Thank you. Yes, so as, you're entitled to ask the witnesses questions, and certainly Chief McCarthy is here as a, town department, so please.
So once again, I was merely asking for the chief to highlight his education, training, and experience, and in particular with the kind of operations and the sorts of areas of inquiry that the commission was posing questions on, so that our record is complete.
So I'm a 40-year veteran of the fire service, having worked in a volunteer department in college, and served 27 years for the town of Westport, rising through the ranks and ultimately serving as their fire chief until 2005. I served as the city of Norwalk's fire chief from 2005 to 2015, and have been the fire chief and emergency management director for the town of Fairfield since October 1st of last year. I have a bachelor's degree in fire science administration from the University of New Haven, have attended the National Fire Academy, the State of Connecticut Fire Academy, fire officer development programs, as well as incident command and management programs at the National Fire Academy and at Texas A&M, in broad terms.
Thanks. Do you have any specific questions for him on his background?
I don't have anything further regarding background, but I would like to, just before I begin my presentation, ask a couple of questions on sort of follow-ups to questions by the commission, if I may, Chief.
Please do.
First, if you could just highlight, in terms of a response to a fire, whether it happens to be a false alarm caused by a malfunction of equipment, or a child grabbing a fire alarm, or indeed in the event of an actual small or large-scale event, can you just highlight sort of, first of all, whether the response is different in any way with respect to any one of those events, and if not, or either way, can you tell the commission what happens in that instance, in each and every instance?
So a fairly regular response by the fire department would be for emergency medical call. In Fairfield, if someone dials 911 and reports that they're having a heart attack or other significant medical emergency, they'll get a fire truck, an ambulance, and a police car. And that's our standard response. So that's the lowest level of response. But there are other events that would get a single engine responding to a facility like this. If there is an automatic alarm, and because of the potential for life loss in a residential building with a very high occupancy, we treat that as a very significant event and over-respond because in the interest of time, if we just sent a single engine to investigate and they find out it's a fire, then they're going to be ineffective in saving lives and protecting property. We will, have lost precious moments as the fire develops. So for automatic alarms, we send 2 engines, a truck, and a command car. And should there be a fire, would, as I testified earlier, get 5 engines, 2 trucks, or a truck and a rescue, a command car, as well as Southport volunteers. And we would assess the circumstance once we arrive and determine whether units would stage out on Bronson Road and not commit themselves into the driveway, or whether additional units are needed. If the circumstance required, we would call mutual aid and other resources to the scene.
And am I correct that in the event, you referred to an automatic alarm?
Yep.
In the event that someone leaves a piece of toast in a toaster oven for too long, or in the event that there's an actual, I don't know what you call it professionally, but an actual serious event, am I correct that the expectation is, whether it's a beautiful day like last Friday or whether it's a winter night where it's 5 degrees out and we have 18 inches of snow on the ground, as we did not this past winter but the winter before, you expect all the occupants of that building, whether it's the middle of the day or at midnight, to leave that building? Is that correct?
If the fire alarm goes off, we expect every resident of the building to leave. As a matter of fact, we will detail the first arriving units to make sure that everybody is out of the building.
And once again, in this instance, you're aware that there's no sidewalk area, and certainly if there's snow on the ground, the only areas that would be clear would be the driveways on the site, which is where your equipment would be operating and entering the site. Am I correct?
Yes, and that was the issue that I raised and testified, that I would expect that those evacuating residents would interfere with the responding units.
And with 91 units and however many cars are potentially at the site, and with 91 units and people of varying experiences, interests, and needs, such as the need to be at work in an hour or two, or in the event that you are actually burned and want to get to medical care, or in the event that you have a new car that's located right under this building that's on fire, potentially, contrary to sort of what I heard of some statistic that people like to watch the fire, would it be your expectation, based on your experience and training, that there would be at least some residents attempting to leave the site, if not many?
If there are 6 automatic alarms or responses by the fire department, if the experience at the other Fairchild facility indicates as an average, people will get in the habit of recognize, or at least they'll recognize, that they are going to be boxed in. Should they have appointments, should they have to get to work, should they want to protect their car, should they just want to get out of the weather, they will get in their car. And that will present a congestion issue for that single access road.
And if your equipment is on site and there is an incident that requires either active fire fighting or venting the building, that sort of thing, can you give the commission some notion as to how long fire equipment needs to be on station, on site, parked in front of the building, or some notion of it? I understand that it would vary in every instance, but at least some scale on that.
If there is a fire, we will be on site for, again, if there's a car fire in the garage, then we'll be there for hours. And the residents will be out of the building for hours. It will require the building official to arrive, the building owner to be summoned to the scene. Decisions about reoccupancy will take a significant amount of time. And that's a simple car fire that potentially drives smoke up into the building. If there is a fire in the building, portions of that building may not be able to be reoccupied for some time.
And so in terms of the turnaround and its location and its proximity and where your equipment would be located, can you comment on how the location and staging of your equipment would potentially be affected in this instance?
So the turnaround really doesn't, given its location, it doesn't help that much the fire department operation. When we look at that narrow space as you come around the corner of the building by the entrance to the garage, there is a choke point. And if we're going to put up a ladder, it's got to be positioned So we're not going to position a ladder there because of the peak of the roof. Will prevent that ladder from actually gaining access to the roof. So the location of the turnaround, other than turning a vehicle around, doesn't significantly improve fire department operations at a fire.
And the operations might certainly affect the use of the turnaround, though. The contrary.
So there will be equipment, as I showed in the submission from Assistant Chief Bisson. There will be equipment that will be stacked in that access road in the area of the turnaround.
So can I then assume that if, for example, one of the cars you spoke about catching fire were located, say, in this area, and I'm referring to what I'll call the southwest corner of
Just
the building.
show them what you're referring to, please.
I am looking at plan 2 of 9, and I'm referring to the southwest corner.
I think you might, yeah, you might, just for the record, I think you're going to need to use some microphone as well.
Sure, fair enough. So I'm referring to sheet 2 of 9, and in your experience, for example, if there were a car that caught fire, as you've described, in indeed any portion of the area under the building, on the western end of the building, or indeed even in this portion, even in this outdoor area, these 3 spaces to the west of the building, where would you be staging your vehicles in order to deal with that event relative to the turnaround area?
So a fire in the parking garage by that entrance may, given smoke conditions, may prevent us from accessing the balance of the parking lot. Equipment in that case would be stacked up in the access road.
And indeed, if you're operating here to deal with an event, you could not turn a truck around as proposed by the applicant at all.
Right.
And also, can you comment in your experience whether you've ever encountered in Fairfield or in your the previous departments you've been involved with, are there instances where a project has a lack of adequate parking? Have you experienced cars parking in fire lanes, for example?
A area of concern, and one that we typically ask the police department to intervene, is when cars are parked in the fire lane, specifically around holidays and where there is more than the expected population and not enough parking.
So if, for example, once again, a car were to park in this fire lane area that is proposed by the applicant, in this turnaround area, that completely eliminates any ability of vehicles to turn around on the site.
Yes.
I have nothing further. Thank you very much.
Yeah, you actually inspired one other question
Well, I'd be happy
of me.
This might be timely.
to Chief McCarthy. I had one other question. You just inspired me, if you would. Thanks. So, is the purpose of the turnaround is multifaceted. It's not just to be able to turn the fire truck around. It's actually additional blacktop in a place where you're positioning the vehicles and doing your job on the site. To maneuver around the site.
There is a very limited amount of free asphalt available to the fire department, and we would use every bit of that in order to resolve any emergency that occurs. There are so many different variables that would influence. You think of whether it's a fire in the parking lot, fire in the parking garage, fire in the building. It would, and depending on which portion of the building, any number of configurations of apparatus in that space are conceivable. but there is a limited number we are not able to maneuver very well, given the lack of access to the building by blacktop. And that has been our concern from the beginning.
Got it. Thank you.
Sorry, Chief, I know we're giving you a good workout here.
Last time, I promise. Last time.
You may not have to go tomorrow either at the rate we're going here, but in terms of, in terms of the report that was prepared by the department, it speaks in terms of a collapse zone, but can you just comment on, and I think this is probably common sense, but it tends to be better when an expert comments on it than when I comment on it. The location of a turnaround zone, besides the factor of collapse danger and not wanting to have vehicles exposed to that risk, would it also be fair to say, based on the sorts of activities you've identified, that any turnaround zone would not want to be proximate to a building in a space where you might be involved in operations, and you'd want it several hundred feet, or I don't know how far, but far enough away from the building so that it would not be, the ability to turn around would not be impacted at all by operations or on operations?
Let me answer it this way, and hopefully it will clarify our concern. When we first looked at the property and the configuration of the drive, it was our desire, and understanding the wetlands and the limitations of the footprint of impervious surfaces, our preference would be to shift that parking lot towards I-95 or the asphalt towards I-95 to get away from the building. We want to be close to the building, but we don't want to be underneath the shadow of the building and jeopardize our equipment and personnel. It's not effective. It's not an effective vantage point. It's too close to raise a ladder to put it up on the roof, even an aerial device on the ladder truck. Some physical distance from the building is necessary to protect our personnel and equipment, but also give us the advantage of using the equipment in the way that it was designed. The location of the turnaround just gives us proximity to the building, but I'm not sure that it gives us a tactical advantage.
And once again, going back to the sequence of response in the event of an automatic alarm, you have a pumper truck coming and a ladder truck?
That's correct, for an automatic alarm. Two pumpers and a ladder truck and a command car.
And is there a sequence at which they arrive?
They are on duty. They are typically stationed in predetermined firehouses. We'll have a ladder when the next vehicle is purchased at Reef Road and one at Jennings Road. However, all sorts of circumstances affect the order in which they arrive on scene.
And I note that there is a hydrant find it on the two drawings here, but depending on where the access to water is and where the pumper truck is located, potentially that pumper truck could be located in the turnaround and it hooks up to a hydrant potentially. Is that correct?
Is my recollection there is a hydrant in that general area. Once a supply line from the pumper to the hydrant is laid, it effectively blocks all other vehicle movements, and I'm at a loss to tell you off the top of my head. Maybe the consultant can tell us exactly where the hydrant is.
And if a pumper is hooked up to the hydrant, could a pumper potentially be located in the area that's been designated for turnaround?
It could be.
And operationally, what would be involved in moving a pumper to facilitate other trucks taking advantage of the turnaround?
So the turnaround, you're referring to turnaround as a operational space during the emergency. Once the vehicles are positioned, they're not going to be moved. Typically, they aren't moved once they are in operation. So regardless of whether a ladder truck is there or a pumper is there, they are not going to be moved because it becomes very difficult to move equipment at an active emergency scene unless, really dire conditions require it.
So what I'm hearing then is that the turnaround is great unless there are fire trucks on the scene. I'm sorry, but I had to throw that out. As I understand it then, any operations would impede or impair the ability to use the turnaround that is proposed.
The turnaround is, by design, intended to be used when we're leaving the scene. It is a footprint that we'll use while operating at the scene, but it is not designed for tactical advantage in fighting the fire.
I don't know if there are any follow-ups at this point, but all right. So I just want to, first of all, comment briefly on sort of the discussion that occurred at the beginning of the applicant's presentation. I would like to present the commission with pages 8 and 9 of the decision.
We have the decision.
I just have an easy page, one single page highlighted copy there.
You just hand this to the whole stack, we'll pass it around. Thank you.
So I just, we struck me that we don't have to look too far, and I thought there was a lot of discussion, yet it seems like in many ways this is fairly simple, and that in terms of the court's wording in the highlighted area of the exhibit that I've provided, and I'd like to just address some of the court's comments. First of all, the court does specifically say, and it is a matter of health and safety, and there is that finding in this case, that the ability of fire trucks to enter and turn around in the parking lot is critical as a matter of health and safety. But the court doesn't just limit it to that. The court also speaks about moving in large delivery trucks. So I'm kind of struck by the fact that the applicant's presentation really did not address sort of what I'll call non-fire department equipment at all. And I think that that is also certainly a significant issue in terms of this site, and the court specifically points out, and obviously it's not necessarily a matter of life and death in terms of a moving truck or in terms of another commercial vehicle coming in on the site, and then I suppose it could be. For example, I think we can deal with the court's comment. In the case of moving in delivery trucks, it might be possible to unload their cargo into smaller vehicles before going too far into the site, or to use the same turnaround as proposed for the fire trucks. Well, certainly I'm not a traffic expert, but if you look at the driveway from Bronson Road, there is no way and nowhere for example, a moving truck to park anywhere on that 20-foot access for any length of time and unload anything into any truck. There is no staging area on this site, so I found this sort of a curious comment by the court, and certainly the applicant on remand and with its engineered drawings did not demonstrate that there's any such area on the site where that sort of staging can be conducted. But I will offer some expert testimony on that shortly. So I think that we can dispose of that sort of option, because just as a matter of common sense, you can look at the site plan and see that that is not possible. But similarly, though, I did not see anything in the materials submitted by the applicant that deals with a moving truck, a tractor trailer that might come off I-95 with the address of 92 and 140 Bronson Road. I had a neighbor who moved recently, and there was a van line truck that came from California and had 3 different loads of 3 different households of furniture and personal belongings in it. It pulled up to the house, it was out in our street, and unloading. And that driver could easily come off of exit 20 or Bronson Road exit there, pull into this site at any time, and pull deep into this site and pull right in front of this building. Now, that truck could be 45 feet long, that truck could be 50 feet long, that rig with tractor trailer could be 55 or 60 feet long. Where's that going? And where's the data for this commission that satisfies you that that truck can back out of the site, that that truck can turn around in that turning area? Where's the data on that? And by the way, we have highly trained and highly skilled drivers for our fire trucks in town. What's the standard for any driver from anywhere driving a tractor trailer truck into Connecticut from anywhere? Where's the safety there? Where's the assurance of safety there? Where's the assurance of someone backing a truck of that magnitude up on this site that has no sidewalks and attempting to use a turnaround? And the applicant offered you nothing on that. Nothing that showed you how that goes or how that truck gets turned around. And the court once again specifically finds the ability of moving and large delivery trucks to do the same is an issue of health and safety to a lesser degree. It's in there. And there's no basis for this commission to find that the applicant satisfied that on remand. What I would like to do now is to introduce Alan Shepard. Alan is a professional engineer with NOK in Shelton, Connecticut. He's been a professional engineer for 36 years now, and he's been specifically involved with Nowakowski, Obima Kane, NOK, for over 25 years. Amongst his activities is site planning and layouts for municipal, residential, and commercial projects, once again for over 25 years. In addition, for 5 years, he worked for industrial risk insurers. He developed recommendations to lessen the possibility of physical damage to industrial properties due to fire, explosion, collapse, flood, and windstorm. He followed construction of new buildings, and I would ask him to come forward, and he's looked at the turnaround specifically, and I would ask for Alan to offer his findings with respect to the turnaround. I do have a resume for Mr. Shepard that I'd like to submit into the record.
Please do. Thank you.
Well, for the record, John Shepard, professional engineer.
Sorry, yeah, you need to stand up at the mic.
Stand up here closer. With the firm Nowakowski, Obima Kane, 415 Howe Avenue, Shelton, Connecticut. And I've been a professional engineer for over 25 years. Out of college at 36 years.
Thank you. Do you have something to submit? Okay. So you can just hand that all to our clerk, and she'll pass those around. Please be sure you give one to the applicant.
And I'll put one on the board in case I'm...
Terrific, thank you.
Attorney Green requested that I take a look at the turnaround area that was proposed. So, basically I took a focus of that area with a, what I used was a bus, a 40-foot bus, which is pretty close to a fire truck, has the same similarities to it. 24 feet between the wheels. And took a look at how that turns around. Now, you could have two backup movements and turn a vehicle out of the driveway, but there's a couple points that I want to highlight about that. In step number one, if you're pulling up next to the building and you go to back around, you're getting very close to the dumpster area and may clip the dumpster area. In step number two, you're going into the fire lane, and as some of the board members pointed out, the wheels have to touch the back curb with the overhang of the vehicle over the curb. That could be important if you have snow conditions. Last year, we didn't have, the snow wasn't all that bad last year. But the couple of years before that, we had tremendous amount of snow, and there was problems with snow removal and getting it out of the way. So that could be an issue during certain conditions. Step three, you pull up close to the dumpster, you pull back around, you're getting close to the handicap parking space over there, and again, the back wheels have to go off the paved area up against the curb. If there's snow piled there, that would be problematic. Not to mention people coming and exiting the building. Before we pull out, and the way I could only get it coming out that it looks to me they may go over the curb where they don't have the raised curb. So
You mean off the pavement onto the grass,
onto the grass.
not on the mountable?
Because they have the mountable curb in this area past there. There's a gap in between the dumpster area and the mountable curb. So I was having difficulties to get it back on. And you really got to take a look at the vehicle with the outside rigging and not only the tires where they go, but the overhangs of the vehicles. Sort of like when you're backing out of your garage, if you're not paying attention where your front bumper is, depending on what kind of vehicle you have, you can hit the garage even though the wheel's farther away from the garage or the trunk area. So it's very tight in that situation. So my point being that although it could be possible with two backward motions, we normally like one backward motion if we're going to have a turnaround area, and it should be free and easy to access. If you have foul weather conditions, or you have commotion going on where they can't get the truck perfectly lined up, you're most likely going to have 3 backward motions or 4 backward motions to get the vehicles out. So that's more excessive. I would say that would not be adequate in my opinion. The likelihood that there's, in the wintertime, if we have sprinklers going on and there's sprinklers underneath the car area, it's going to freeze in that area also. So the sprinkler system itself causes a lot of freezing on the driveway because they're going to spread out. That fire truck may not be able to maneuver perfectly when there's a condition out there. So that's my overview of that turnaround area. It is very tight, not perfect, not pristine, and not adequate in my opinion.
So am I correct then that what you're saying is that every single turnaround would have to be absolutely perfect in order to take advantage of this turning area with the 2 turns?
I worked hard to get it aligned on paper, and it's much easier to move a piece of paper around on a drafting table than it is a large vehicle.
And so does this present a safe turnaround area for a 42-foot fire truck?
Not in my opinion.
And What about the larger vehicles that I talked about? What about a moving truck? What about another large vehicle?
Attorney Green did ask me to take a look at other vehicles. A moving van, I had, I just couldn't get it to work at all.
When you refer to a moving van, are you referring to a tractor trailer?
Tractor trailer, and I want to be clear with that.
An 18-wheeler, like a, Beekman's, whatever, right?
Right, a moving
The doors
van.
on the side and the back opens and the whole...
Correct, a tractor trailer truck, to be clear, because they have different sizes of moving vans. So a tractor trailer truck, just gonna get it to fit. I looked at a box truck, which was more like the rental moving U-Haul 30-foot truck. And I can get that to turn around, somewhat better than the 40-foot truck. But I'd still need two backward movements to do that with, to get that motion to turn around, so it's still walkable.
So, we're dealing with health and safety issues, not convenience. So if a truck needs to take 3 turns to turn around, then, that's one thing. A lot of folks do use, moving companies, as Attorney Green mentioned, that use tractor trailers. And so, we do need to consider that according to the court, as to whether the turnaround or the layout of the property provides an ability for those trucks to enter and turn around in the parking lot, safely. Right? So can you speak to that a little bit?
Yeah, I don't think they can actually, a moving tractor trailer truck, I don't think they can actually move, once they get into the property, I believe they're backing out. The driveway does have curves to it, so there's a difference between a 20-foot wide straight driveway and a 20-foot wide driveway with curves in it. So the more curves, the more difficult it is. If it's a straight shot, it's easier to back out. So I think with a moving van, tractor trailer truck type, I can't see where they could turn around. Like I said, if they have one of these smaller 30-foot box vans, you still have confusion there because they have to back out twice, and that's if they're a good driver. If it's a rental type of situation where you got a novice driver, I doubt if they'll get it in 2 points. They may be 3 backward motions.
And can you comment on the location, to that point, can you comment on the location of the turnaround area in your experience in laying out sites for commercial or industrial residential uses? Can you comment on the particular location of the turnaround area relative to the flow of traffic, relative to the building, and relative to parking?
Sure. Due to the parking area and layout area, when you're coming around, you may not, the visibility isn't the greatest there, so you have 2 driveways coming together. If you're taking a backward motion when you have people come out of the driveway, it's not the most optimal part, and it does look like they have projections for the building out there, and they could have landscaping out there that would really block the visibility of that truck turning around into the fire backup area. So we would want a turnaround area to be open, away from the building, easy to define and accessible, so there's nuances to that if it doesn't look like a turnaround area, there's confusion. If you have it away from the building, clearly defined, clearly marked, then it's more usable.
I don't know if the commission has questions for Mr. Shepard.
Commissioner Barrett.
Mr. Shepard, you work for this firm that prepared this,
I'm a partner in the firm, yes.
You're a partner in that firm. Did you live in Fairfield or do you live in Shelton?
I live in Newtown, Connecticut.
Okay, so you're just here as an expert. You don't know, other than your review of this project, you have no interest in this particular application?
None whatsoever.
Okay, thank you.
And can you just comment, Mr. Shepard, briefly on whether, in your professional opinion, the proposed turnaround sort of compensates for the lack of a second access to this site in terms of accessibility and safety?
And I don't want to speak for the fire chief or the other experts that are before you, have been before you. But what I'm hearing and when I take a look at it, if you had, there are multiple things to a turnaround area or fire protection to a site. So if you had an open space, you're out in a field, you're not restricted, you have a area where you can set up and remove people from, that may be suitable for one access because you have other options. Or let me put it this way, a suitable turnaround area may make up for that, right? I think what, having a lack of a suitable turnaround area is the issue there that you can't overcome, because if it was suitable and you had a nice open area where you can have a turnaround area, stage people from, that may be safe. But having that in combination with what we have, this does not overcome that threshold, in my opinion.
As a matter of safety, is that?
As a matter of safety.
I have no further questions.
Thank you very much.
So once again, in this instance, I don't think that we have to look deeply into the, and sort of get involved in where the margins are on the remand, because at the heart of this remand is the issue, once again, of health and safety. And once again, just looking, right down the middle on this thing, on this application, the court, in the middle of the paragraph that I highlighted on page 9 of the decision, once again, finds that these issues of access and ability to enter and turn around in the parking lot are issues of health and safety. I think that certainly the chief and Mr. Shepard have highlighted, I'm sorry,
Whenever you're in a good spot, I have a question.
have highlighted the fact that the proposal, the turnaround as it exists, is not safe. And once again, the applicant has offered virtually nothing on what I'll call non-emergency vehicles, on sort of the moving trucks, the beacons moving in storage, or others that we've talked about. Or indeed, I see my neighbors, the truck will come from Asheville, North Carolina, the furniture capital of the world, and down our street, and it's a 50-foot long tractor trailer, and they're coming through residential neighborhoods. So what is to, once again, stop any particular driver and trucker from pulling into this site and being confronted with the same lack of turnaround and having to back 300 feet out? And I understand I'm going to the margins on the remand, but one thing's for sure, it can't be turned around on the site, and that is an issue of safety. So I don't think we have to go too far to find that the applicant has failed to meet its burden on remand of demonstrating a safe way to turn vehicles around on this site, and the application on remand should be denied for that reason. I'm happy to answer a question.
Thanks. So, I touched upon it just before. It's not your contention that the 42-foot bus turnaround is, that the turning around of a 42-foot bus is unsafe. We saw a plan for that to be turned around. It might take 3 or 4 movements, but it turned around. Now, there may be some snow or weather issues that would cause that to be a problem in certain circumstances, But is it your contention that that's unsafe?
It is unsafe. It is bizarre to me to take a site and at the most heavily traveled portion of the site, where there's this choke point on the site, to put that as your place where every vehicle has to back up, has to pull, and unless a fire truck driven by a skilled driver has to pull forward and back up every time, or indeed, how many UPS trucks come on that site? How many U-Haul trucks come on that site? There's 91 units on that site. Everyone is ordering online now. Everyone has UPS trucks and FedEx trucks buzzing up and down their street. And the turnaround happens to be in a location on that site that is right at the entrance to that building, a building, once again, with 91 units, probably 200 residents, all of whom are going to drive cars because there's no public transportation there. There's no sidewalks. Every pedestrian coming and going from that site, kids going to their school buses, people who do go out for a run, people who go for a walk, or people going anywhere, every pedestrian has to walk directly through the turnaround area that this applicant has proposed. The same turnaround area that all those delivery trucks, everyone coming to the site has to use to turn around. And that is, in my mind, and I have to keep saying I'm not a professional engineer, but experts are based on your knowledge, your training, your experience, and experts offer an opinion. I don't need an expert to tell me that having that amount of traffic and that turnaround as the sole place you can turn around on that site, I don't need an expert to tell me that's not safe and that's a bad location for a turnaround, and I wouldn't think this commission needs that either, but we have provided that expert testimony tonight. And I'm sorry I'm a little bit exasperated by, you'll forgive me, but the sort of the path this application has taken. It's frustrating to me that we have sort of come to this place where if you actually step back and go back, and before we all got involved with the first application, the notion of putting 91 units or 95 units or 96 units just boggles my mind, and I understand the context and of which we appear, but if you step back, this makes no sense.
Commissioner Cannelli.
I just have one quick question for the chief about the fire lane, if I could ask him. I'm sorry to make you get up again, Chief. I just have this one question, because I don't want to assume something that I don't have the experience, because I'm looking at this and thinking about it. But you, as you mentioned in your discussion of your CV, you've worked both in an urban environment and also in a suburban environment, Westport and Norwalk. Right. And so I'm going to throw something out. I want you to tell me whether this is reasonable for me to be concerned about. You can decide that. As I look at the safety of the operation of the turnaround, one issue is that the fire lane that's been created and is very much a critical element of allowing the movement in this space comes from what had previously been parking spaces. And my question to you is my assumption would be that on private property like this, isolated as it is, not in a, say, someplace in Norwalk where a fire lane would be clearly lined up, you'd know it, a cop would be driving by on the beat regularly, hand out a ticket, maybe parking enforcement would do that, they'd see a striped fire lane. This is fairly isolated. This is not necessarily something that every day a cop or somebody from parking enforcement is going to go through. So here's my worry, and I wanted to ask you as an expert professional about this. Should I at least be a little nervous that over time, that this fire lane, isolated, not likely to be a place where tickets are going to be issued very often, might become an attractive place for visitors to park, because of its isolation, as opposed to being, say, in an urban environment or an environment more connected to the rest of the community, like you might have experienced in Norwalk. Have you seen that in your experience, that fire areas that maybe wear down over time and are isolated can become spots where people may, especially visitors, may choose to park? What do you think about that? Is that at least a consideration?
I think it's an important consideration. If there is, limited parking, especially during high volume events, holidays and the like, it does become a very attractive location. As opposed to parking on the street, where you clearly be obstructing traffic. I think that there is the potential. I would say that every fire lane is an attractive location, and it requires a lot of vigilance by the fire department and the police department to monitor and enforce the fire lane. In an isolated location like this, it becomes problematic.
Thanks very much. Thanks, Mr. Chairman.
Thank you. Commissioner Barrett?
No, I don't have anything else.
Nothing? Okay. Anyone else?
So I certainly want to thank the commission for your generous patience and attention for hearing me. Thank you.
Very good. Thank you, Attorney Green. Is there any other member of the public that wishes to be heard on this? No? All right, hearing none. Attorney Fallon?
Thank you, Mr. Chairman. I think what I'd like to do is call Mr. Versteeg. I think out of courtesy to the chief, to the commission, and to the record, I'd like him to respond to some of the comments that are contained in the report, and also some of Chief McCarthy's comments tonight, and then I'll have a few closing remarks.
That would be great. Thank you very much.
Thank you. For the record, Joe Versteeg, Versteeg Associates, representing the applicant. I think what's important to understand here is that the Connecticut Fire Prevention Code, which is adopted pursuant to 29291A of the Connecticut General Statutes, the 2015 edition. There have been two of them in Connecticut, the 2012 and 2015, contain only 5 requirements, very basic requirements, for fire department vehicle access to the site. Now understand, this is a national document developed by the National Fire Protection Association, members of the International Firefighters Association, International Fire Chiefs Association, building officials, safety officials, as well as property owners, sit on this, evaluate the input from the membership or the public at large, anywhere in the world. Anyone can submit a proposal. They vote on it. There is also voting done by the overall membership, and it's published. The state of Connecticut, as an administrative regulation, adopts this, posts a notice in the Law Journal that we're going to adopt it. There's actually a 15-member statutorily mandated advisory committee of fire marshals throughout the state of Connecticut, specifically intended to address rural communities, large cities, medium-sized cities, suburban cities, so there's a cross-representation of input that takes this document from the national level and evaluates it for use in Connecticut, to turn it into a document that is unique to Connecticut. They have not altered in any way the 5 basic principles and requirements of this code that I'm about to talk about. In addition, the document is published in the legal journal. Once it's developed, it goes before the Attorney General of the state of Connecticut for legal sufficiency. It goes before the Public Safety Committee of the state legislature, and then it goes before the full body of the legislature and is adopted and enacted as an administrative regulation of the state of Connecticut. As I said, for fire department vehicle access, there are 5 basic requirements. 1, you have to have access into the property. We provided a single access road. The requirement then says that you have to have at least the 20-foot width of that road. And we've discussed that in detail as to why the 20-foot width is adequate. You also have to be able to get a fire truck within 50 feet of the exterior door. They don't want a building that's on top of a mountain that you park the truck and then have to walk 5 miles to get to the building. So this access road, the driveway into the site, provides the fire department vehicle access within 50 feet of an exterior door. The second rule...
Great. Before you get to the
Yes.
second point, may I interrupt you?
Sure.
To ask you a question about the first point.
Yep.
Thank you. Chief McCarthy cites NFPA section 18.2.3.3
Right.
with respect to this access road that you're talking about. And he recites that more than one fire department access road shall be provided when it is determined by the AHJ that access by a single road could be impaired by vehicle congestion, condition of terrain, climatic conditions, or other factors that could limit access. And he, as the AHJ, having reviewed the plan, has determined in his report that there are these other conditions which merit his opinion. How do I square the two? Please help me with this.
Yeah, the authority having jurisdiction defined by the Connecticut Fire Prevention Code is that of the state fire marshal. Local fire marshals in each community are allowed to make the initial determination as to compliance. If there's a question as to their accuracy on compliance or their interpretation or they're unsure, then the decision goes to the state fire marshal. The local fire marshal here, who enforces this document, not the fire chief, not the fire department, in many jurisdictions, the fire marshal is not even a member of the fire department.
So your contention is that he is not the AHJ?
100% correct.
Okay.
Yep. And don't forget that the fire marshal in Fairfield has already reviewed this on 2 occasions and determined compliance. So he's made the initial determination that this complies with code. The fourth rule is not only do you get a fire truck within 50 feet of an exterior door, but then you have to be able to walk around the building no more than 450 feet. And that prevents a building that you arrive at the front and it's 9 miles long. There's some reasonable distance, and the committee's decided that 450 feet. And then if the driveway exceeds 150 feet and is dead-ended, the code simply requires a turnaround. And that seems to be the whole crux of this tonight. As Chief McCarthy stated, the turnaround provides no tactical advantage or operational edge. It was never intended to. It's merely there so a fire truck operator doesn't have to back a fire truck up over 150 feet in length. And if this property were close enough to the street that the driveway dead-ended at 149 feet, there would be no requirement to have a turnaround, and the fire department would have to back the vehicle up 149 feet.
Well,
It's simply an added safeguard for when driveways get dead-ended over 150 feet.
well, it seems to me that the court is digging into this a little bit more deeply than simply minimal compliance with the code to ensure that the site has adequate protections for public health, safety, and welfare, such that the fire department can enter and turn around in the parking lot for the purpose of health and safety. And so my question is whether the minimal requirements that you speak about are in all cases the end of the line, and that in no cases do you ever have conditions that warrant additional fire protection measures, additional turnaround space, additional whatever it may be, that go beyond the code.
Just to clarify, if you're asking Mr. Versteeg that in the context of his expertise in the fire code, that's fine. If your question goes to the legal standards under 8-30G, I will address that in my final remarks.
Yeah, Mr. Chairman, the purpose of me testifying and providing guidance on this project is simply for compliance with the legally required requirements of the Connecticut Fire Prevention Code.
Are there circumstances in which the compliance with the minimal amount required by the code are not sufficient in certain circumstances to protect the public health and safety and welfare?
There might be, but I haven't seen them in this project.
Commissioner Barrett said, next question.
Mr. Versteeg, you testified in the initial application. Sorry, I keep forgetting. I apologize for that. I'm just trying to avoid unnecessary noise. You were, I recall from the first from the application, I'm sorry, there's not a first application. The application, you were the applicant's expert in terms of fire safety. And I would just ask you, did that application have a turnaround? Initially, when you spoke, when you testified here? Do you recall?
No, the initial design provided sufficient, although difficulty, that you could back the vehicle around.
Right. But
Back the vehicle around or back the vehicle up?
Back it up and make a reverse direction.
See, I
and
thought-
drive out.
And I get that, but I thought you're just educating us on a new 5 basic requirements, and you said if the driveway exceeds 150 feet, it requires a turnaround.
Right.
So the initial application didn't have a turnaround, but you were here telling us.
No. The initial application had the ability within it for a vehicle to turn around. This is a much better turnaround and more clear cut.
Okay, so it requires a turnaround, but it didn't have an adequate turnaround, so this is a better turnaround.
Right, and that gets to the issue that had been raised about, the turnarounds in close proximity to the building. Nothing prohibits that, nothing requires it. The fact that we make 2 turns, 5 turns, 6 turns, and an inexperienced driver is going to have more difficult, none of that is addressed in the code.
Yeah, I know, I'm struggling, because I understand your background and expertise, but a lot of your responses are just relate to the code, which is fine,
Right.
You're going to that, but I see more site-specific information here, and then it's more refined to with the code. And then again, you say it requires a turnaround. Well, the first application, you say, I had the ability to turn around. Well, not adequate.
So no, I think that what you're saying is that your role here is to testify about the compliance with the minimum requirements under the code.
The only requirements of the code, that are applicable to this project.
Okay, Commissioner Kennelly had a question.
for Mr. Estig, real quick.
We did offer, you recall, the turnaround as part of the original proceedings, at the very end.
No, that's all dealt with in the court's opinion.
Yep.
We couldn't consider it, it wasn't reviewed by the town, it wasn't drawings, didn't have radius on it. It was remanded actually to you to prepare fully engineered plans and a revised proposal, which you've done, which we're now considering. Okay, so I think that if I'm understanding Mr. Versteeg's testimony correctly, is that the first proposed, the original application had the ability for fire trucks to turn around, and that is what he was considering to be in compliance with the code at that time. Is that right, Mr. Versteeg?
Yes.
Right, and so now he's saying this is simply a better turnaround, and so it too is in compliance with the minimal requirements of the code, correct?
Exactly.
Commissioner Cannell?
Mr. Estig, when you testified before us last time, it's my understanding under questioning by Mr. Green, he asked you if you had visited the site, and you said no, that's correct?
Correct.
Did you visit the site this time?
No.
Okay, so you have not visited the site in either time you've come before?
No, I
us.
have not.
Thanks.
Okay. Now, there's a number of other issues that have been raised, collapse zones and operational needs and vehicles coming down the road and people standing wherever. I think Chief Bison stated it best in his memorandum to you, that lengthy document, that Fairfield Fire Department uses the National Fire Protection Association Standard 1620, which is the standard for pre-incident planning that fire departments use to evaluate buildings and sites and potential hazards and access thereto and potential events therein, and how should they operate, how should they respond, how do they set up, and they use that as a document to develop plans that address all of the topics that were raised and issues that were raised by Chief McCarthy tonight. So I have no doubt that the Fairfield Fire Department can adapt to any of these changing situations. And keep in mind, as in war, you can have all the plans you want, but the minute the first shot's fired, those plans go out the window. So these are pretty much standardized guidelines, but every time you arrive, things are different, and they all are based on tactical decisions made by experienced commanders, such as Chief Bison and Chief McCarthy. I think in summary, simply put, that everything we have proposed complies with the 2015 Connecticut State Fire Prevention Code, and no topic raised by anyone here during this hearing is in fact a violation of that same code. Unless there's any questions, I thank you.
Thank you.
And I thank you. And I'll try to be brief, and we certainly will be brief enough to curfew by your regular time. Again, I stressed what I did at the beginning because having reviewed the fire department report, whatever its good intentions, it seemed to me that it went much farther afield than the scope of this remand that brings us here tonight. And with all due respect to the chief, there was discussions with regard to types of construction, density of the project, both in the report and tonight. And I really don't think that is appropriate. If you go back to the decision, which is where I will end up, at page 4 of the decision, starting at page 4, Judge Bates discusses the access way width. He goes through great detail going on to page 5. And I won't read that to you because I know, like most of us, you probably know this decision fairly much by heart. One thing I would point out, because I think it addresses a legal issue that the chair referenced before. In the second to last paragraph on page 5, Judge Bates states, and I quote, talking in the context about the access way, under the applicable fire codes, the minimum acceptable width is 20 feet, and that level of compliance should generally be sufficient for an affordable housing project. And he quotes or cites the old Farms Crossing Associates versus Planning and Zoning Commission case. So I think it's important, because the chairman asked before, if in fact a minimum standard contained in a fire code meets the standard with regard to public health and safety that you would apply here, sufficient to overrule an affordable housing project. And I think the totality of Judge Bates's decision answers that question.
That's an interesting point, because, you know, as Commissioner Barrett's just went through with Mr. Versteeg, he testified that the fire code requires a turnaround, and the original application had, in his view, a turnaround, but the court found that it was insufficient under the original application and required something more.
I think
a better
you interpret,
turnaround.
again, Mr. Chairman, respectfully, the court's decision differently than I would. I think what the court indicates in its decision is that late in the hearing process, an offer of an alternative was made by the applicant, and that the commission and that the court remanded so that that could be considered with appropriate plans.
But hold on, before we move away from that, because I really want to understand where you're coming from.
Well, right away.
Because on page 8, the court says, this is 1, 2, 3, 4, 5, 6, 7 lines up. The commission argues that forcing large trucks to reverse that distance creates a health and safety concern that outweighs the need for affordable housing, and the court shares that concern. So clearly,
You've
the
now switched from the width of the access to the adequacy of the access in terms of two accesses.
The width is the width. I mean, the court has found, and the court is saying, that 20 feet is going to be 20 feet. You widened it. They asked us to consider whether the 2-foot wider, extension of that, and frankly, if the court found that 20 was fine, then 22 is going to be good too.
Right.
And so, but I'm trying to understand if it's not related to health and safety, related to the fire apparatus and such, and what is it related to then? If it's not health and safety?
I'll address that, and I'm moving to that now. What I did want to point out, though, was you asked a question before, when Mr. Versteeg was up here, about the interplay between compliance with the fire code and the public health and safety standard applicable to affordable housing. And what I quoted to you in the previous remarks was the court saying that if the fire code requires 20 feet, then that minimal compliance satisfies the standard.
Didn't say satisfied, said should.
No, it says
should
generally.
be sufficient. Said should be sufficient.
Correct.
Okay?
Correct.
And further in the opinion, it remanded for us to look at revised plans because the original plan was not adequate to protect health and safety.
I would indicate to you...
And compliance with one aspect of the code should be sufficient, but compliance with another aspect of the code might not. We're dealing with life and death here.
Mr. Chairman, you're entitled to your interpretation of Judge Bates' decision. I don't agree with it.
I just have to do my job.
I'm not saying you're not, and I'm doing mine, but I don't think the judge's decision indicated that he was remanding this because he felt the turnaround was inadequate. You may differ, but I don't agree with that. Let me go back to the lack of the second access way for an apartment building, which is discussed at page 8. This whole proceeding tonight, it seems to me, focused substantially on that. I ask you to read the second paragraph contained in section D. I don't think it can be clearer. As to the general needs of another accessway, Fallon cited NFPA Table 5151A for the authority that a single means of access is sufficient for a building of this type with less than 100 units. He also provided the commissions with standards promulgated by the American Association of State Highway and Transportation Officials, which allows a single means of access for a building of this nature. Fellner and Spear did not contest these authorities, but argued that a second means of access would be safer. Again, the court finds that while other means of vehicular access to the site would be desirable in terms of safety, it is not required by the applicable NFPA or AAS HTO codes and is not feasible for this site. Given that the single access appears to meet the minimum level of compliance, it should be sufficient for an affordable housing project. I don't know how much clearer the judge can be on that issue.
Should be, but then
Okay.
he continues to say, but you've got to look at these issues which pose a risk to health and safety.
No, what he says, in fact, on page 9, is on the final night of the public hearing, the applicant submitted a sketch featuring potential conditions of approval regarding this issue. This proposal eliminated 4 parking spaces and 3 units and purported to afford larger vehicles such as fire trucks and moving vans sufficient space to access the building and the turnaround so as to avoid reverse travel while exiting. The commission did not consider this offered alternative and did not have staff analyze it, given the lateness of the submittal in the hearing process and the fact that it was not appropriate form. Pursuant to 8-30GH, the applicant could have, following the denial of the application, taken advantage of a statutory right to resubmit. The commission, however, stated that it would not even consider the conditions of approval because of other public health and safety concerns were not amenable, namely the 20-foot access way. Given this court's holding that the 20-foot access wide way is acceptable, the court will remand the issue of the most recent redesign of access way and apartment building discussed above and proposed by the applicant for due consideration by the commission. I'm not going to read the whole decision, but I think that he did not make a finding that anything with regard to the original plan was inadequate. He did warrant that the issue of the access of the turnaround be reviewed.
I just want to be clear, because on page 8, the court says, the court shares the concern that the original proposal creates a health and safety concern that outweighs the need for affordable housing. That's page 8, 1, 2, 3, 4, 5 lines from the bottom of the page. There's other stuff after the stuff that you just read. I just want to be clear. You're telling us that you do not believe that the judge remanded the revised proposal back to us to consider issues of health and safety?
With regard to the turnaround, yes. But not with regard to the access, the single access way, for example.
But
I think that decision has been decided already by the court.
But the turnaround and the access way, in some way, I mean, they're 2 different issues. In some way, don't you think they go hand in hand?
No, I don't.
I mean, there has to be an adequate, if the road is more than 150 feet, there has to be an adequate turnaround that is functional and enables the police, the fire to do what they need to do to enter and move around the site sufficiently. If the turnaround is not safe, doesn't provide efficient or adequate health and safety, then there's an issue with the single access way.
I don't agree. I think on this record, the matter of the width of the accessway and the propriety of a single accessway have been adjudicated. I think what has been remanded back to you is consideration under the standard you promulgate of the proposed turnaround.
Okay. Can you show me where here he says that the single access way, there's a holding that says that there's only one?
Yes.
No need to?
I just read it to you. It's on page 8. Given that the single access appears to meet the minimum level of compliance, it should be sufficient for an affordable housing project.
It should be.
Right.
But then the court goes on to say that it's not, because there is an insufficient turnaround, which the court shares a concern about health and safety.
I respectfully don't agree with that interpretation, but in any event, I think the matter of the sufficiency of this turnaround has been addressed by the applicant.
Okay.
I think, again, I think the shoulder is not the issue that has been the focus here, but the shoulder was something that the judge asked at the bottom of page 9, all parties to consider this proposal on remand. Well, it's to be considered. The Wetlands Agency has approved it. I don't think there's much more to say about it. With regard to the matter of other vehicles, briefly, and the testimony that was offered by Mr. Shepard, a couple of things. The fact that a moving truck might have to execute, depending on the expertise of the driver, 2, 3, or 4 maneuvers to exit, it strikes me, is not a matter that rises to the level of public health and safety sufficient to outweigh the need for affordable housing. One other thing I just have to bring to your attention, and I apologize, I wasn't going to bring this up, so I didn't bring sufficient copies. So just look at it. This is a site plan, or a submission as part of the site plan. Of the Commerce Drive project. It was approved by this commission, I think last summer, and is presently under construction. As you know, in addition to retail space, it also was approved for 110 units of housing. I don't belabor it, but I point out to you that if the determining factor with regard to, or a determining factor with regard to applications such as this, is going to be maneuverability and access for large non-emergency vehicles. I don't think that standard was applied here, because clearly a moving truck moving in one of those 110 residents at best is going to end up parking out in the middle of Commerce Drive.
Well, this site doesn't have an access way that's over 150 feet, does it?
But still, show me how a vehicle is going to access other than blocking Commerce Drive.
But I think we're talking about apples and oranges here. I mean, I want to understand your point, because I think it's important. But the requirement for the turnaround is presented because the access way is more than 150 feet. Here, it's 300 feet long, okay? And there's no sidewalks, and there's, right? So we then find ourselves struggling with, okay, well, what is an adequate turnaround here? Because
Correct.
On the testimony that we've heard and the reviews that we've had from the experts, the preferable scenario would be that we have a second access way. That's not feasible on this site. Okay, well then we need to have a turnaround that is adequate, as the court says. It's gotta be, the distance creates a health and safety concern that outweighs the need for affordable housing, and the court shares that concern. Okay, fine. So now we talk about maneuverability on site, whether there's an adequate turnaround, et cetera. None of those features are shared on this Commerce Drive site.
It's offered solely to demonstrate that if the issue here is accessibility for non-emergency vehicles to a multifamily housing development, but the primary thing that I think...
Non-emergency, so that's the issue.
Yeah,
The distinction there was
I
non-emergency.
think by way
versus
of the emergency vehicles, the issue is code compliance.
Yeah.
And we do comply. And at the end of the day, we offer an improved, more delineated turnaround that I think addresses responsibly the court's considerations on the remand. And beyond that, there was some conversation with regard to, what inadequate parking could do in terms of some of these collateral issues we discussed. But of course, in the decision, the court found the parking as proposed to be adequate. But at the end of the day, look...
Right. No, I think that the issues of the parking that were raised were in the context of an emergency event. And in combination with the location of the turnaround, in the context of its purpose, and whether the parking issues might somehow pose a problem with that. And, you know, I certainly would be interested to hear what you have to say as to that.
No,
if anything.
I think it's speculative in the sense that it assumes a parking inadequacy that the court found not to exist. But at the end of the day, since the real focus here is public health and safety, because we're all in agreement on that.
I gotta tell you, this is really,
All right, Mr. Versteeg, in his opening remarks, spent a fair amount of time explaining how the fire code is adopted, how it is reviewed, how it is imposed, how it is enforced. The arbiter of public health and safety is compliance with the state fire code with regard to whatever you're proposing. If this record on remand demonstrates one area of non-compliance with the code, then you should reject this application. But it doesn't.
But the code has certain things that are desirable. The code says you have to take into account local circumstances and the different considerations that are applicable with respect to any particular site. The code says that the AHJ should say, you know, make a determination, etc. And I want to know your response to this. The first application that was submitted to us, Mr. Versteeg said, is compliant with the code. The court reviewed that and said the forcing large trucks to reverse that distance creates a health and safety concern that outweighs the need for affordable housing, and the court shares that concern. Implicit in that finding is that mere compliance with the code is not sufficient in all circumstances. And what we've heard from Chief McCarthy tonight is his opinion that the circumstances of this site require perhaps something more than the code. And so I want to hear how you respond to that.
The court's comment that you cite was directly related to the matter of the turnaround, which was remanded and which we've been discussing tonight. The turnaround, in fact, does comply with all standards, and it is safe. And there is no evidence in this record that there would be a public health and safety issue with regard to this turnaround that sufficiently outweighs the need for affordable housing in the state. At the end of the day, however, the court's decision in other aspects, which I cited, also stands for the proposition that code compliance is generally, that's the term he uses.
Can be, unless there's
Generally,
evidence
not
to the
can be,
contrary.
not-
It says should be, unless there's evidence to the contrary that you need to consider, right?
I don't want to belabor, I promise you I finished
We got 10
before
minutes.
11, but my voice
This is
may not.
important. This is important stuff.
Whoa.
You said there's no evidence that it's unsafe. I had an expert, the chief of the fire department for our town, stand in front of me and tell me that this is, it's not safe.
I think the chief's comments were wide-ranging, but I think on the issues that are germane to this remand, the turnaround and the 2-foot permeable shoulder, the chief offered no evidence that, in my mind, would justify a finding that the inconvenience that can be associated with the turnaround creates a public health and safety issue. And all of the other comments about people coming outside where they go, that is directly related to the code. And I think that there, the code does set a standard for compliance.
No, I think you made those arguments in your opening remarks about the notion that there could be evidence either submitted in the materials in writing or adduced through oral testimony that exceeds the scope of the remand. And we have to do our job in considering the evidence that's relevant to the issues before us and make a decision on that. And just because it's in the record doesn't mean necessarily that, you know, it will be considered and would necessarily, you know, carry the day.
I respect
okay?
that.
So I wanted to make that point
Respect
equally clear.
Thank you.
Right? So,
Thank you.
does anyone else have any questions? Okay? Very well. Thank you, Mr. Fallon. Thank you, Chief. Thank you, Mr. Green. Attorney Green. I will close the public hearing on this, and I will adjourn the meeting.